Who is for the petitioner, sir?
I am for the petition. This is
What is this?
there was 5 participants in the tender matter who have been that non-responsive, and 3 are the eligible
What?
participants. The petitioner quoted 9.99% less, and the opposition 5 quoted 6.49.
Oh,
Both
that's
are
matching. That matching one.
Same category,
Yes.
both the.
So who is
And,
for the state? Who is for the, who has floated a tender?
The Lordship classification directed me to obtain instruction on this point, my lord. I have obtained instruction, my lord. And they have stated in the instruction that as per the resolution under annexure P, my lord, they have.
How? Whether they can do it within their authorities? Have they disclosed in the tender? Have they disclosed that this, if they wanted to have a matching, then in that event, he should also be given an opportunity to lower down his all the procedures have been followed. Show us that what procedure you have followed. What procedure? Where is the provision for inviting a matching? Show us. Any clause, anywhere, show us.
Yes, sir.
Where is the provision for negotiation?
Yes.
You are a cherry picking, blue-eyed person. We'll consider you. We'll hear you.
I was indicating the truth.
Yes, we will hear you. We'll hear you. That how it is done. Yes. Tell me, sir. Where is your, very boldly you have said that I have followed all the procedures. Show us that what you, show us from the tender document that you have indicated. Show us.
In OPWC code, my lord.
I have read, sir. I have read, right? Resolution file. I have seen. Let us see. Resolution must be in consonance with the. You are changing the rule of the game when the game is already played. Let us see. Show us from the tender. Show us from the tender. That you have indicated that if there is a tie amongst one or two, then others who have quoted more, they will also be called to negotiate or match the price.
But in the tender document, my lord, that is not clearly stated. That's not sure.
Yes. There were 2 persons, there was a tie between him and another person. You have called third. Now all 3 matches. Show us where, how, in what manner you can do. Show us that how can you relax Rule 18 of OGFR Volume 1 and Para 3.1, 5.14 of OPW Court. You have taken shelter under this. Show us. Oh, this is that also. Scheduled caste and scheduled tribe. Oh, this, they are under, they belongs to the unreserved category, both Sadhu, Nimika and there is another,
Number 5.
K. Maulidhar
But that is general cat. I
and
am
Sadhu Nimika. Sadhu Nimika
Scheduled trial.
Scheduled trial.
And Shashi
and K. Maulida is unreserved.
Man.
And I am scheduled task.
Show us. You showed that provision yesterday, I think last time. And the interpretation which you want to give was not actually the same. This OPW code. And what is this OGFR?
Also general financial rules. What is the general financial rule?
Where is that? Yeah. No. It's not expected. When you read it, this paragraph, your authority has referred two promises. He says that we have done it in relaxation of Rule 18 of the OGFR and this one. Then you should brought OGFR point. Then he says that 3.5.14 of the OPWD code, then we should also bring that particular to us. And then show us that how those are applicable.
And I got this information this morning.
You can't just receive and then come out to read it, but justify the step. You should have a consultation with them when they come and hand it over. That whether I can justify it on a parameter of law. The most important thing.
My business can you take note of what is
What is happening?
very
Now, let him hear, let us see how he justifies your stand. He is siding and taking advantage of your stand. No, that's.
First is, your lordship will kindly take page 26. 26 clause 1.7.4.
1 point as Thomas. You were not the lowest bidder. You quoted a price higher than. But the authorities have called you and you have varied your quotes on the bid. And then you matches with your. And then now you are favored with the order. Being an L2. And the authority to do so. There must be a clause in the tender that in the event if bids are open, then all the bidders will be given an opportunity to match the price quoted by the lowest bidder. If this exercise has come, then in that event, what is to be done? The difficulty here is what I find is matching concept are sometimes I may be correct or maybe not is invited so that the entire the voluminous work which involves a volume to be done. So they wanted that it can be distributed amongst 1, 2, 3, so that if one fails, if the things goes on and there is no disruption, I can understand you divide. Here you have decided to go for a lottery. Lottery means person who is still in the financial bid is stood as L1, yet either you are a lucky one by this exercise, or we cannot rule out the possibility of use two terms, nepotism and favoritism.
And if Malak finds that there is some inherent biasness or arbitrariness, Malak, your lordships can always
Yes,
interpret.
what more? Can you change the rule of the game?
Yes.
If the tender does not prescribe for these kind of an exercise to be undertaken. The rule which was given is that a preference was given to an SC/ST. If there is a equal tie between a candidate who is an SC/ST and the candidate who is undeserved, then the preference can be given to SC/ST. If I correctly remember the clause which was shown to me. There was already a one SC/ST. He may not be allotted, but
May therefore make by May I supplement? Let's first, your lordship will kindly take page 26. It says clause 1.7.4 of the tender,
yes,
page 26. 1.74, not 7.4, 1.7,
26.
26. Is this also, I believe, very well from your lordship. Last week, whether the provisions of OPWD code will apply.
Yes.
1.74. Over and above these conditions, the terms and conditions.
1.7.
Yes, over and above these conditions, the terms and conditions and rules and regulations and specifications as laid down in OPWD code, Rich code, MOSRT and H specifications with latest revision or amendment are also binding on the part of contract.
What exactly?
So let's
So by
OPWD
this
code
reference, the provisions of these OPWD codes
get
that
supplied.
has been imbibed.
Now your
No
lordship,
different.
now your lordship will kindly take appendix 9A, volume 2 of the OPWD code, clause 21.
Follow?
Volume 2, Millers. Appendix Roman 9A.
Appendix 9.
9, Roman 9A, capital.
That's true.
Yes.
Roman 9, yes, A, executive instruction.
Yes, Millers said clause 21, Millers will see. Let's have it.
Yes.
Negotiation of bids. For examination, evaluation, and comparison of bids, the officer inviting the bid may, at his discretion, ask the lowest bidder for clarification of his rates, including reduction of rate on negotiation and breakdown of unit. So, Millers, here your lordships now have seen which is the provision which governs the aspect of negotiation. Now, if I may draw your lordship's attention to how I become the lowest bidder for which I was invited for negotiation. That's the next threshold I have to cross. Now, Millers, we'll kindly see this regulation, this resolution, which is annexed, which admittedly, Millers, it's nobody's, it's not a disputed case, that a price preference of 10% will be given. That is,
Sir, if you read this, what does it mean? Let us see. I just be hurriedly placed.
but yes,
Let us go very slowly. Read each words.
month.
It says for examination. There is a spelling mistake. Evaluation, it should.
Millers.
It has been given EVALL. The as and comparison of bids. The officer inviting the bid may, at his discretion, ask the lowest bidder for clarification of his rates, including reduction of the rate or negotiation and breakdown of unit rates. What does it mean?
May I answer? Millers? It says,
Means the lowest bidder may be asked to clarify his rates. And by word of say inclusion, it has given expansive meaning of reduction of a rate of negotiation and breakdown of unit rates.
But
When,
he is the lowest bidder.
when, and everybody is invited to ask for that whether he is intending to negotiate. Now, question is, the difficulty which arises is, if a lowest bidder has quoted, I think the bidder has quoted the lowest rate, then he has to ask for, the clarification. I don't say. Then you have quoted the lowest rate. What you have quoted as the rate? And he asked to go further down. He has to ask to go for further down. So what it means is that suppose he is the lowest bidder.
But
He has quoted 50 rupees. Others have quoted more than 50 rupees. He may be asked to say, will you go down further? Will you go down further? Can you go to 48? Can you go to 50, 47? For that purpose has to have the more competitive rates. But it does not mean that he is the lowest bidder, and then, sorry, he's not a lowest bidder. Lowest bidders are something, and the person who is the highest bidder, he is called to match. Here is a situation, you are the highest bidder. They are the lowest bidder. You have been called highest bidder to match the lowest bidder. Any is this a spirit of this provision? I don't know. Otherwise, this word, who is to be called, asked the lowest bidder. What is the meaning of the word lowest bidder? For clarification of his rates, including reduction of the rate on negotiation and breakdown of the unit. So this is what they wanted, that yes, you have quoted the lowest. Can you go further down? Can it be applied reversely, conversely?
yes, may I just answer that?
Please read that. That is important. He is called the lowest bidder. Now, when they are calling him, he is actually a highest bidder. Or say higher bidder. He's not a lowest bidder.
May I answer that? By what?
The lowest bidder who will.
Here, your lordship will see kindly see who are the bidders. Will kindly take.
So there are three persons who have come.
Yes,
I have seen them. One is he, another is another gentleman who belongs to a reserve category class. And you are also claiming yourself to be a reserve category. These two persons have quoted the lowest price. You have quoted the higher price. You have been called to match the lowest bid. Can you take advantage of this?
yes. I explain this. Your lordship will kindly take page 5 for page 5
Of
of the writ petition.
two.
Now, let's will see Sadhu Nimika. There is a list there.
No, that is not.
Yes.
I was looking at it. They have, what
Let's see, just-
tabulation has been done.
Yes, may I just make
No
my
difficulty. Sadhu,
Sadhu
9.99. Murlidhar, 9.99.
Right.
He is Murlidhar, I believe.
No,
Or Sadhu.
Sadhu.
You are
He is Sadhu.
Yeah. So this is the general.
I am Shashira.
Correct. And now you are a Mangaraj.
Yes,
You are a Mangaraj.
Right.
You have quoted a higher price.
ma'am.
Now.
May I
am
let's
asking,
make.
Yes.
Millards, your lordship will see 9.99 is quoted by the petitioner. 6.49 is admittedly quoted by,
Higher.
so I am higher. Now, Millards, when your lordships, for the purpose of valuation, Millards, when the price preference is taken into account, then 10% gets added. So 9.99 becomes 19.99 and 6.49 becomes 16.49. Now, Millers, that being the case, I may kindly draw your lordship. So, Millers,
No, this is what is the base price, whoever quotes less than 10%, because that is the barrier which is given. A bidder cannot quote minus 14.
he can go up to a maximum
That
of
is the 10,
14.99%.
you are adding it, sir.
But after adding, Millers, I am entitled to get a price preference of 10%. May I?
Then how? I'm very interested, the things. When you brought the mathematical, the calculation, then if your price was 16 point something, and their price was 19. So now, if it is not minus, if you are adding it up, so you are definitely lower than him.
Yes.
You should be L1. They have not declared you as L1.
And
What
yes,
you are doing is reverse mathematics, sir. That's a very difficult situation. What I find in these kind of a tender is that 10% is the base price. One cannot quote more than, but means less than 10%. May I rephrase the sentence? He has to quote. So they have definitely gone 9.99. That's the maximum that is below 10%. That I can give you my price is lower than this, up to this. They are just going,
let's kindly see that
there
case.
is one mathematical precision equal to 10%.
Let's kindly see that case at para 11.
I remember my days over there.
Yes.
When a council finds nothing to argue on merit, then no one technicality.
No, I'm
Pleading is
technical.
defective. This pleading is defective, the prayer is
It's not
defective.
pleading.
There's
So,
not
well, I'll make my case.
announcing cause of action which is already pleaded, nothing of that kind.
Well, I'll make my case.
I was also.
Well, I'll make my case. Well, let's kindly, therefore, let's kindly take for a moment para 11, page 6. Para 11 minutes, we'll see. Page 6.
Yeah.
It is further humbly submitted here that the Works Department resolution dated 30th October 2018 has been made applicable in the.
What is there? SCST.
Yes, I am also an ST.
That is off. You kindly go by that resolution of.
I'm showing that. I'm coming to that. I'm coming to before that. I
They
will.
are quoted. They in the instructions they are quoted. What it says. This is what I think they have not given it to. Clause 3, 2 or 3 is to be read. That 2 and 3 is to be read.
Yes, the concessions.
The concessions or the facilities for 10% purchase preference shall be allowed only to the individual registered contractors belonging to the scheduled caste and scheduled tribe having registration certificate up to B class.
Yes.
If the tender of the individual registered contractors belonging to the scheduled caste and scheduled tribe is within 10%, within, that is what I'm saying, that's the outer cap. Within 10% of the rate quoted by the lowest tenderer for any work, the work may be considered for awarding him at the lowest tenderer rate in relaxation of Rule 15 of the Orissa and para 3.5.14 of the OPWD code, the volume 1. The security deposit has to be granted. Now, if the question is that if there is already an SCST bidder and he has quoted the lowest bidder, and there is another SCST bidder who has quoted the higher price. Can this apply? It should apply when there is a general category contractor and the reserve category. They are comes vis-a-vis each other. that it is ST and ST was to be given a preference. Just to uplift them. That's the constitutional goals. When the resolution was brought, just to uplift them so that they should be given a preference. So that we can uplift their standard, people uplift them, give lot of supports, everything to them. So that's a very, I would say, pious way of looking at the thing. There is no discussion. But amongst the reserve class, can you do it a competition? Can you? He's already an SC/ST or somebody else is an SC/ST. He has quoted a price, will he not? Then another person will come. Amongst them, the competition. That is not the spirit of it. The spirit is general, reserve is the reserve, then the reserve category should be given a preference. When there is already a reserve category candidate who is L1, why there will be another this device?
Let's see here, you can see clause 2 of that resolution.
I need to stop.
We all are sometimes facing the wrong end of the gun. But your lordship will kindly take clause 2 of that resolution. It says the concessions, facilities for 10% purchase preference shall be allowed only to the individual registered contractors belonging to SC/ST having registration certificate up to vehicles. So, beloveds, 10% preference is always there to be taken by me by virtue of the fact that I am an SC/ST category. Similar to the petitioner, I am also entitled to a 10% preference.
The object and the purpose of this resolution has to be ascertained from the very first one. And then what are the decisions that should be interpreted in this way? The first paragraph of this resolution talks about the government has extended certain concessions to the scheduled caste and scheduled tribe contractors regarding award of PWD works with VD resolution number such and such on the basis of the recommendation of the court's legal committee. It has now been decided to modify the aforesaid resolution and allow the following facilities to individual scheduled caste and scheduled tribe contractors for execution of the PPWD. First, the scheduled caste and scheduled tribe applicants desirous of enrolling themselves as contractors are required to deposit 50% of the amount specified for various classes of the contractors under the 7 of the Constitution. So this concession that they may not have to deposit the entire amount, if the others will deposit 50%, they have to. The concession of facility for 10% purchase preference shall be allowed only to the individual registered contractors belonging to scheduled caste and scheduled tribe having registration certificate up to B+. If the tender of the individual registered candidate belonging to scheduled caste is within 10% of the rate quoted by the lowest tender for any work, the work may be considered for award to him at the lowest tender rate in relaxation. So it is only to promote the contractors who belong to a scheduled caste and scheduled tribe. It does not mean that there will be a competition amongst the individual registered contractors belonging to scheduled caste.
Let's, your lordship will see there are 4 benefits that are given.
He is there to get it, sir.
Let me, let's
SC/ST.
if your lordship will kindly permit. 4 benefits that are available to be given to SC/ST category of bidders. First benefit, your lordship saw, was that they are required to deposit 50%.
That's a concessional rate.
That's a concession. First concession.
Concessional rate
Yes.
that has been given. No,
Second concession that is given is that
10% barrier. 10% barrier.
Plus, it is, may I make that case? Concession for 10% purchase preference. So that shall be allowed to all the bidders.
True.
So by virtue of allowing that 10%, I have reached 16.49 and he has reached 19.99. But the law says, the code says, somebody can maximum quote 14.99%. And if there are more than one bidders who are quoting 14.99%, then there will be a lottery. So, Bilals, that provision, your lordships, is
What the reverse? He's adding. He's adding up. That's a 10% barrier. Minus 6 point something. Minus is of what? 10. 10. It is 10 plus 6. He is saying 10 plus 6 means 16.49. And it is a 10 plus 9.99 is 19.99. Can you believe? Yes.
Bilals, kindly, Bilals, it's not just what I am submitting, it is the petitioner's case also. That 10% shall be added, I mean, or shall be further reduced, if I may kindly say. Bilals, what exactly is the case? 2.58 crores is the value of work that is evaluated by the tendering authority. Now, they will accept the bids of those people or award the work to those people who gives the lowest bidder, but that undercutting of from that 2.58, because that has its restrictions. You can't undercut it beyond a permissible limit. There is a ceiling limit.
That is a 10.
That is 14.99. Well, will therefore kindly see. That's my humble submission, Millers. If your lordship will see page 30. Well, I will kindly take page 30.
Yes.
If the rate quoted, Millers, I'm reading second para from the bottom.
No, page 30.
30.
Yes, that is the clause you give.
Yes, clause 2 Millers.
2.
At the bottom.
At the bottom. Amendment
Second.
to appendix 9.
Appendix 9, clause 36 of OPWD code by inclusion. Clause 36. If the rate quoted by the bidder is less than 15% of the tendered amount, then such a bid shall be rejected and the tender shall be finalized basing on merits of rest bids. But if more than one bid is quoted at 14.99%, decimals up to 2 numbers will be taken for all practical purposes, less than the estimated cost. The tender accepting authority will finalize the tender through a transparent lottery system where all bidders, their authorized representatives, their concerned executive engineer and DAO will remain present. So, Bilals, when the rate quoted by more than one bidder is 14.99%, and this I say, Bilals, comes to 14.99% after the 10% price, and Bilals will, your lordship have seen this. Now, your lordship will kindly take page 11. Page 11, Bilals, will kindly take. I'm sorry, page 6. Page 6, para 11. That it is further humbly submitted here that the Works Department resolution number such and such has been made applicable in the present contract, as would be evident from the DTCN, which says that if the rate quoted by the SC/ST category contractor comes to 14.99% after availing 10% price preference, then the tender shall be finalized through a transparent lottery system. Therefore, it is very much clear that petitioner, being scheduled tribe contractor, is entitled for the benefit, and as such the letter issued by OP5 for negotiation is liable to be cited. But in any event, it is their positive case and it is also coming forth from the OPWD code clause 36. That 14.99% is the maximum, and if that ceiling limit is reached by more than one bidder, then it will result in a lottery. Here, after giving the price preference of 10%, I would have reached 16.49, he would have reached 19.99, but the maximum that is available is 14.99. So Millets, both therefore, that is petitioner and OP5, that is me Millets, both are at 14.99%. And therefore, Millets, I also become the lowest bidder by virtue of that. And therefore, Millets, I was invited
And
for
why you were included in the lottery?
Millets.
Why you were included in the lottery?
Millets.
Why? If the prices are one and the same, then why the lottery will be held?
That's what this clause says. That if more than one is there,
Oh, so there is no, everybody has quoted more.
14.99%, me and him.
That is what after you matches.
No, not after matches, even without matching, for a moment. 16.49 plus 10, 6.49 plus 10%.
How much?
It is 16.4.
Correct. And
The-
9.99 plus 10%.
But maximum that
Now
is
tell me, 9.99 plus 10, how much it comes? 19.99? If that mathematics goes,
no. If
straight away, you are taking 6.49 plus 10 as 16.49, then equally, he has quoted 9.99 plus 10, it is 19.99. Very simple mathematics.
yes, but
And where is the matching?
But
The
the-
rates varies.
but the
And
max,
you, according to you, you were the only sole, the lowest bidder. They could have proceeded to grant you or award you, but why they asked for a lottery?
may Miller's indicate.
That cannot be done.
14.99%. Miller's is the highest that is permissible. That's the highest or the lowest. I'm sorry, is the lowest that is permissible. So after the price preference, the lowest that both the bidders, OP5 and me, both SC/ST category, can go is 14.99. It cannot go to 19, it cannot go to 16.
Then both have to be concerned. And then according to you, neither you are on 14.99 can go, or but it means minimum. You cannot go below 14.99,
Malas.
or you have to be close to 14.99. What?
At 14.99%, both.
What? How? Tell me the mathematics. You have quoted minus 6.49. He has quoted minus 9.99. How both, by what mathematical procedure, both will come to 14.99?
That's the highest that is
I'm
permissible.
asking you, sir, how it comes.
Let's if that
Unable to understand this mathematics.
if that price preference is taken, then 10% is available. Now today, if Malas, may I give an example? Let's explain by way of an example. If I would have quoted, let's say, for example, this 13.49, 3.49 instead of 6.49, then I would have been given 10% extra, so it would have become 13.49, which is not the ceiling limit. Ceiling limit is 14.9, and therefore, Millers, your lordships, I cannot be, me or both the petitioner cannot be said to have exceeded more than 14.99% because that is the ceiling. It is by virtue of, Millers, there is a preference.
Then according to you, it's absolutely a farcical approach. Those who have quoted taking into the barrier of 14.99, then everybody should be invited.
I'm not saying that. All I'm saying is both of us are at level playing field.
Price bid has no
And your lordship,
meaning at all.
and your
I
lordship,
don't think so that it has any meaning.
and your lordship,
Anyhow,
kindly note one
Yes, now I am not going to
Let's one last submission.
make any observations. You complete your argument.
Let's one last submission if I may kindly make.
Yes.
Let's the petitioner has never objected to the lottery. He himself has participated in the lottery. His authorized representative participated in the lottery. After having failed,
Annexure 6, madam.
after having failed,
Annexure 6, I have objected. Sorry.
Millets, the lottery was held on 13/6/25. Has he ever said that he has not participated in the lottery? He has participated. He was, Millets, your lordships knows that if he participates, because that itself, he cannot now, after losing out in the lottery, he cannot now say that it was, plus there were 3 kids. There are 3 names, 3 bidders. It could have been his name also. had it been his name, he wouldn't have come here before your lordships, challenging the tender process. After failing, after my name comes out in that lottery system, which was transparent before ever, his case is not that it is not transparent. After that, Millets, he has come before your lordship. Now, Millets, there are three benefits that are given.
Only one is
One is price preference. Second is whether I have to satisfy your lordship, whether my client is entitled to a price preference, whether he's entitled to be invited to the negotiation, whether he's entitled to be invited to a lottery. That's the case, Millets. Yes, sir. Now, insofar as price preference is concerned, 10% I don't want to repeat, I've already submitted. And insofar as this negotiation is concerned, I am the lowest bidder together with him. And he is the lowest bidder. So, in any way, by virtue of that 9.99%, I am entitled to match him. My humble submission, is that there is nothing amiss in the process. That is my humble submission. If your lordship will kindly permit, I'll put in my reply. I'm appearing on advance notice. I'll put in a reply.
What put in the reply? Everything is there, the tender document is there, OPWB code is there, what more? It requires only interpretation of those clauses, nothing more than that. So it's a pure question of law which can be decided on I think, impeccable the materials which are here. You can't dispute it.
Very well. In that event, since they have filed the let me be permitted, your lordship can.
We are injuncting you not to continue. We are injuncting them not to.
Yes, the work order is already issued since June. Work order is issued since June.
It will be immediately. Yes. So,
That's all. Sorry. Lordship will permit, I'll put in my.
yes, that is only the tender document. There is no other document.
No.
DPCL?
This is there, annexure 2.
That's true, only.
No.
There is nothing apart from that. Yes.
Their invitation calling for a negotiation is under annexure 4. And for lottery under annexure 5. Annexure 3 is the resolution dated 30 October 2018. They have challenged under annexure 4 and 5.
Yes. Yes. Yes, I dictated you. Told me. I've gone through.
So that's it just bylaw perspective.
Affidavits. The challenges meet
there is a clause that all bidders should file application and grievance within 5 working days, and which shall be considered before opening of the price bid. That is inbuilt in the tender condition. And the admittedly on 14th, there is the opening of the technical bid and the petition of file grievance on 18th July 2025.
Within 5 days.
Within 5 working days.
I have taken instruction, Millard. So far the representation of the petitioner is concerned, Millard. It was received on 18/7/2025, and the department is conducting an inquiry starting from 19/7/2025 on the next day, Millard, and that is pending, Millard. And department had sought for instruction from other departments regarding such nature of such complaint made against the other contractor. Price bid is not opened yet.
This may humble similar before opening of they are going now this
Now they are saying that.
is that with of the
There's no
dispose of
where-
that dispose of
Where is that clause?
Look.
If I explain now.
page 35 plus 22.16
Please.
35 annexure 1 also plus 22.16.
Uh, 22 point.
6 lordships. This, the result of the evaluation.
Yes. The. Right.
No.
The Orissa State Rural Roads Agency noted a tender for repair and maintenance of the rural roads.
Now we see. Who? Mr. V. Sridhar and Zangu. He's driving. Yes, ma'am, he's driving. May it please, your lordship. I'm audible and visible, your lordship.
Yes, yes, you are audible and visible both, sir.
Great. I'm obliged, your lordship.
Yes.
I have nothing more to say. My learned friend wanted to say something.
Your Lordship, Your Lordship.
Actually, only one small sentence. The distinction between court and tribunal, Constitution bench has said, your lordship, specifically, these industrial tribunals are tribunals but not courts.
True.
Those,
Oh, this is that tribunal of the court.
what, Your Lordship. Your Lordship, what I think with great respect to my learned senior, those two judgments, what Your Lordship, my learned senior is like to cite, those two judgments are in different aspect. I'll go to that, Your Lordship. I'll go to that. Your Lordship, so far as the pleadings and arguments, Your Lordship, extensive argument has been completed on the last date, Your Lordship. Only so far as that issue is the court. Your Lordship, I have cited a judgment. Your Lordship, here, Your Lordship, so far as the facts are concerned, here the assessment has been completed based on the pursuant to the.
Don't go by alternative. Don't go by alternative.
Two judgments have been cited, Your Lordship. One judgment I have cited so far as the P. Sarathy case is concerned of Honorable Supreme Court of two judges bench, Your Lordship. And my learned senior cited one judgment in MP Steel Corporation. Your Lordship, three judgments for one particular fact.
Three judge bench.
Your Lordship.
So what to do?
That is divisible. Your Lordship, I kindly looked into page 29.
MP Steel is earlier.
MP Steel judgment, Your Lordship.
Earlier to Sarthi or later to Sarthi?
No, earlier is Sarathy.
Okay.
MP Steel is later. And MP Steel case, what my learned seniors submitted.
Sarthi
In
was
that-
considered.
Yes, Your Lordship.
Sarathy has explained, Sarathy has explained and distinguished. That has been written in the placentum. But Your Lordship, for a moment.
Placentum.
Your
What do you call it, a placentum?
head note, Your Lordship.
That is not a placentum.
Answer.
Placentum, as we learn, is something different for the purpose of very easy reference to be made.
Your Lordship, for a moment, only one relevant paragraph where it has been explained that so far as the Sarathy.
Now, what is the law? A judgment of a coordinate bench.
Your Lordship,
Can you consider a
Yes.
judgment of the coordinate bench? There are two or three situations.
show me.
One is a judgment of a coordinate bench was unnoticed in the equal strength coordinate bench at the latter point of time is one situation.
Your Lordship.
A judgment of the coordinate bench was considered and
Yes.
distinguished on a fact is
Yes.
another aspect,
Your Lordship.
or a judgment of a coordinate bench
Your Lordship.
is not relied upon by another subsequent coordinate bench. Then what would be?
Circumstances, court judgment.
I mean,
only one.
overruled it. Can it be done?
Only one paragraph I may be permitted. to
Only?
quote. Only one paragraph
One paragraph means?
of this judgment, of the judgment.
One paragraph means? One paragraph or 11 paragraphs?
Relevant.
So you will be citing 11 paragraphs.
No, relevant paragraph.
Relevant.
Relevant.
Okay, which?
Answer. Yeah, let's say the past judgment is of Honorable Supreme Court.
Hmm?
Union and Territory Ladakh versus Jammu Kashmir National Conference and another. Paragraph
Correct.
35, your Lordship, may kindly turn to paragraph 35.
Yes.
We are seeing before us the judgment and orders by high courts not deciding cases on the ground of leading judgment of this court. And the subject is either referred to larger bench or review petition relating thereto is pending. We have also come across examples of high court refusing difference up to judgment of this court and this court that elect coordinate bench.
So
has
this is a well-known judgment. Quoting that judgment of
National
I think national is by Justice S.B. Sinha,
Constitution, your Lordship.
probably.
Here, let's see. Constitution bench, five judgment relevant, and where
So
has
it
been
says the law, this what is held there, that even if a particular matter or a point is referred to a larger bench, the High Court should not wait till the judgment of the larger bench is decided. In absence of any express order of prohibition,
Your Lordship.
express order
Your Lordship.
putting a fetter, It can.
Your Lordship, in any case, when faced with conflicting judgment of benches of the equal strength of this court, it is the earlier one which is to be followed by the High Court, as held by the 5-judge bench in National. Your Lordship, I'll go to, I'm an officer of the court, I'll go to all aspects, all your questions.
What about the community of Dadu Vora judgment, which is also of a 5-judge bench of 2005?
Your Lordship,
5-judge bench. If the 5-judge bench, earlier 5-judge bench has taken a particular decision, and if a latter 5-judge bench has taken a contrary view, then what the High Court should do?
Your Lordship, then Your Lordship,
And the Supreme Court says both are binding on your lordship, theoretically.
another judgment, Your Lordship.
Just one sentence,
The
not
next
lighter
judgment
Yeah.
that should be done.
Yeah.
Your Lordship, that
Again, MP still they have not doubted.
no, MP still is Your Lordship in my favor. MP still,
The question is different.
Your Lordship,
What doubts?
MP still, Your Lordship, MP still rather is in my favor. MP still, what my Lord and Senior has that analyzed and distinguished, that there is no distinction. Your Lordship, I will show that particular paragraph. Your Lordship, may kindly, in this particular review petition, Your Lordship, Rainbow, Your Lordship, what Honorable Supreme Court has said, that it is well set position.
Where is Rainbow?
Your Lordship, the second judgment review petition, Sanjay Kumar Agrawal.
Say that.
Your Lordship, Rainbow is the last one.
Rainbow is the last one.
Where in this case, Rainbow is the tag case. So
Correct.
where
And which originate from Odisha.
not Odisha. Rainbow
Why?
is citing because that IBC
Because the
matter.
first case was Sanjay Kumar Agarwal.
Yeah.
So why you are not referring Sanjay Kumar Agarwal?
Your
Yes.
Lordship,
Which
the
paragraph?
Paragraph 20, page 14, 1-4. 19 is the doubtful, and 20, Your Lordship, taking it was of the said observation made by coordinate bench, the learned counsel for the review petition of also so and so, Your Lordship, may kindly 4 lines below. It is well settled position of law that a coordinate bench cannot comment on the discretion exercised or judgment rendered by another coordinate bench of the same strength. If a bench does not accept as correct of the decision on a question of law of another bench of equal strength, the only proper course to adopt.
That is what a community of Dadu Vora says. So that is what I am referring.
On paragraph 23, Santala,
We cannot do this.
that I am well conscious. That I am well conscious, Your Lordship. Paragraph 23, the Santalal, 3-judge bench, Santalal, Gupta and others, Modern Cooperative Housing Society. Your Lordship, a coordinate bench cannot comment upon. Thus, in judicial administration precedent, which enunciate the rule of law from the foundation of the administration of justice under our system, therefore, it has always been insisted that the decision of the coordinate bench, Your Lordship, simplex on a Delhi High Court judgment. Honorable Delhi High Court judgment, Your Lordship, for a moment. Refers of different larger bench of different High Court, paragraph 6. What should a High Court do? Your Lordship's question, pertinent question. What should a High Court do when faced with true judgment of Supreme Court, which is apparently cannot be reconciled with respect to its ratios? The full bench of the Patna High Court in the judgment reported in Swanshaw has held that when there are two different judgments of the Supreme Court, then the High Court should follow the judgment which lay down the correct law. The relevant parts of the judgment are as done. Your Lordship, I leave it to Your Lordship's wisdom. I not waste Your Lordship's valuable time. Next, paragraph 7. Various other High Courts of the country have also held that when there are conflicting judgment of the Supreme Court of co-equal bench, then the High Court ought to follow the judgment which lay down the law more correctly. The opposite judgment in the case of Amar Singh Jadhav relied upon the judgment of Indo-Swiss Time Limited, and the ratio of which judgment was followed by the Bombay High Court in the judgment special and acquisitions and the full bench of High Court, so and so. Your Lordship, all these I leave it to Your Lordship's wisdom. I know Your Lordship is.
The Calcutta High Court view has not been taken into consideration by Justice E.M. Bhattacharya in Bholanath Karmkar's case. there a third, the notion was derived that if there are two conflicting judgments operating simultaneously in the field, then it is a choice given to a judge, judge, to follow either of them, which matches, which is close to the facts
Your Lordship.
of a particular.
Your Lordship, may kindly next judgment, AP Electrical's Honorable Supreme Court, the same thing, same ratio. Your Lordship, grateful. Your Lordship, page 121, para 33. If two decisions of this court appear inconsistent with each other, the high courts are not to follow one and overlook the other, but should try to reconcile and respect them both, and the only way to do so is to adopt the wise suggestion of Lord Halsbury given in Queen versus Lathan 1901, reiterated by the Privy Council in Punjab Cooperative Bank Limited versus Commission of Income Tax Lahore AR 1940. Every judgment must be read as applicable to the particular facts proved or assumed to be proved, since the generality of the expression which may be found there are not intended to be exposition of the full law, but governed or qualified by the particular facts of the case in which such expression are to be found, and follow the decision whose facts appear more in accord, as your Lordship has already said, your Lordship, in accord with those of the case at hand. The vesting, your Lordship. Now, your Lordship.
What to do? There are constitution bench decisions which laid down that what should be the course of action to be adopted by a bench. Now,
Your Lordship, what my respect to submission before your Lordship?
should we go by a constitution bench decision or go by a lesser quorum decision?
If here there is no constitution bench judgment on the direct
I am giving you that judgment. Please find out that the community of Daudi Vora versus,
so far facts are concerned.
there it says that there is no other choice but to refer the parties to refer the matter to a chief justice to constitute a larger bench.
Lordship, but that is to be.
And that was subsequently followed in 2007 as judgment as well.
Go to that empty screen, what my Lawrence Engineer has placed on that day. The relevant paragraph, only one paragraph.
Still, the point appears to be an open one.
One paragraph where it has been held that it is distinguished. There is no distinction. On the last day, my Lawrence Senior has handed me.
Can we make a comment on the observation of the Supreme Court, where it says that it is distinguished on fact as a High Court judge? Can we make such observations?
Relevant paragraph, the relevant paragraph where it has been explained, if there is no distinction, simply what I with great respect.
The last time MP states he has cited some judgments.
Peace Sarothi is on the fact whether Deputy Commissioner of Appeal, the first appellate authority, is a court or not. It said any authority or tribunal in trapping of the court is the court. Your Lordship, so far as the Peace Sarothi. I have submitted on the last occasion section 49(2) as well as section 92 where CPC had been adopted. Your Lordship, page 67 of my learned seniors that know. Page 66, paragraph 34.
Yes.
It now remains to consider the decision of a two-judge bench in Peace Sarothi versus SBL. The judgment has held that an abortive proceeding before the appellate authority under section 41 of Tamil Nadu Shop and Establishment Act would attract the provision of section 14 of the Limitation Act in as much as the appellant in this case has been prosecuting a due diligence another civil proceeding before the appellate authority under the Tamil law, which appeal dismissed on the ground that said act was not nationalized bank, and therefore such appeal would not be maintainable. This court made a distinction between civil court and a court and expanded the scope of section 14, stating that any authority or tribunal having the trapping of the court would be a court within the meaning of section 14. It must be remembered that the word court refers only to a proceeding which proves to be abortive In this context, for section 14 to apply, two conditions have to be made. Firstly, primary proceeding must be a suit appeal application filed in a civil suit. Secondly, it is only when it comes to concluding to an abortive proceeding that the word court has been expanded to include proceeding before tribunal. This judgment is in line with a large number of authorities which have held that section 14 should be liberally construed to advance cause of justice, your lordship. See so and so, and the judgment cited therein. Obviously, the context of section 14 would require then the term court be liberally construed to include within it quasi-judicial tribunal as well. This is for the very good reason that the principle of section 14 is that whenever a person bona fide prosecute to due diligence another proceeding which proves to be aberrative because it's without jurisdiction, or otherwise no decision could be rendered on merit. The time taken in such proceeding ought to be excluded, as otherwise the person who has approached the court in such proceeding would be penalized and for no fault of his own. This judgment does not further the case of Sri Viswanathan in any way. The question that has to be answered in this case is whether suits, appeals, or application referred to by Limitation Act to be filed in courts. This has nothing to do with civil proceeding referred to in section 14, which may be filed before other courts or the authorities, which ultimately do not answer the case before them on merits, but throw the case out on some technical ground. Obviously, the word court in section 14 takes its color from the proceeding word civil proceeding. Civil proceedings are of many kinds and need not be confined to suits, appeals, or applications which are made in court stricto sensu. This is made even more clear by the explicit language of section 14 by which civil proceeding can ever be a revision which may be a quasi-judicial tribunal under a particular statute. So my respectful submission before your lordship is that so far the P. Sarathi judgment has not distinguished here, your lordship. P. Sarathi says any authority or tribunal trapping of a court is a court. Your lordship. P. Sarathi judgment, your lordship. Paragraph 9. Paragraph 9. The Deputy Commissioner of Labour Appeals Madras, which is the authority constituted under Tamil Nadu, has the jurisdiction to adjudicate upon order by which service of an employee or term. He has the jurisdiction to decide whether the order or dismissal passed by employer was valid or not, so and so, so and so. Thus, the Deputy Commissioner of Labour Appeal may not be a civil court within the meaning of Code of Civil Procedure, but it is definitely a court. Your lordship, the appeal was in so far, next paragraph, paragraph 12. It will be noticed that section 14 of the Limitation Act does not speak a civil court, but speaks only of a court. It is not necessary that court spoken of in section 14 should be a civil court. Any authority or tribunal having, your lordship, paragraph 12, any authority or tribunal having the trapping of a court would be a court within the meaning of this.
There is no quarrel to this proposition, provided the tribunal has a trapping of a court.
My respectful submission here, you will see, so far as the factual aspect, so far as the law act statute is concerned.
You have to demonstrate the first appellate authority.
Your lordship.
Here we are not testing tribunals.
Your lordship.
Here we are
Any authority, your lordship.
authority.
I'm coming under it.
But the trappings of the court. That
Your lordship, because
is
so,
what my lord. is
Your lordship.
asking.
your lordship,
The posing a query that
my lord.
whether the first appellate authority under the right statute is a trapping of court.
Your lordship, exactly. At that 77-7,
What is trapping of court?
your lordship.
Yeah, you are putting a more emphasis on the notion
Yeah,
that
that's-
once an authority is vested with the power to decide,
Your lordship.
then it assumes the character of a court and has a trapping of a court.
Your lordship.
Does it appear from those judgments? There are many administrative decisions and the authorities are there to decide it on an administrative side. Does it mean that they have a trapping of a court?
Not appeal of the court in appeal proceeding, your lordship. So far as 77-7, your lordship may kindly turn to the provision again. That 77-7. Everything.
Take a plea of the Income Tax Act also. An assessing officer under section 143 of the Income Tax Act is making an assessment order. And then the order is challenged before the CIT, Commissioner of Appeal, is there. Now, the appellate authority, does it have the trapping of a court? That is the first larger question that arises.
Your Lordship, here, so far as the 77.
Simply because he is adjudicating an appeal, that does it mean that it
I
has?
think one of the earliest case in income tax, ITO is not a court.
It is not a court because adjudication proceeding.
So also first appellate authority.
First appellate authority is in appeal. Why I am submitting, Your Lordship?
Adjudicatory process of litigation starts in the at the stage of a tribunal
No,
in the fiscal parlance.
Your Lordship, the similar power.
Fiscal statutes, wherever you see, it is the adjudicatory adversarial adjudicatory process begins at the tribunal stage, not at the appellate stage.
77.7 and 78.5 both are similar power.
You are not
78.5.
addressing that issue. You are addressing the issue.
Your Lordship, for a moment, 77.7 and 78.5. 78.5
First
no
of all-
power has been given.
First of all, tell us whether adversarial litigation begins at tribunal stage, unlike GST, or at the first appellate stage. First appellate stage is only extension of assessing authority
Your Lordship,
as per VAT statute,
Your Lordship, I bow down.
akin to income tax statute.
Your Lordship, Your Lordship,
So when you accept the position that IQ is not a court and appellate authority is the extension of assessment.
Your Lordship,
So corollary would be
Your Lordship, my respectful submission, 78.5 is the power of the tribunal, 77.7 is the power of the first appellate authority.
You say that he has been vested with the power to exercise those powers.
Power.
Oh,
Power.
I appreciate.
So far as the 92, section 92 of the VAT Act, the provision of CPC is equally applicable, Your Lordship.
No,
so
what restricted sense only for attendance of the witnesses and examination of the witnesses,
No.
not lock, stock and barrel that every provision of the civil procedure code will have.
I bow down, Your Lordship. Not entire CPC, Your Lordship.
then ignoring section 2.
No, section 2 says, Your Lordship, only appellate authority's definition is appellate authority is related to 77. Only that is the definition. Not any more that it is his administrative authority.
Further. Tribunal also is different.
That's right.
It is constituted.
Now, Your Lordship, I leave it to Your Lordship.
Don't
Because
give up in the midst.
the laws are very clear, Your Lordship. So, Your Lordship, this is the issue. This is the particular. And why, Your Lordship? Only that citizen power. Your Lordship.
Because in MP Steel, the Supreme Court, in a latter judgment, though considered P. Sarathy's case,
Your Lordship.
but there was one distinction which the learned judges of the Supreme Court wanted to flag there was that Section 14 has to be read in a more pragmatic manner and should not be, the interpretation should not be restricted to one word.
Your Lordship.
What it says is that when we talk about the court, then treating that word court as a civil court,
Your Lordship.
that is not really proper. The court, something has to be, but there was one missing link which was there in Sarathy's case, that the bench did not consider the preceding word, which was a civil proceeding. Both are occurring or appearing under Section 14 of the Limitation Act. So the MP still says that no, when you are saying that, you should also keep in mind the preceding word civil proceedings, and which does not mean that any kind of a proceedings have to be included within that. So it says that if the proceeding cannot be said to be a civil proceeding in that way, then 14 invocation is unwarranted.
Your Lordship.
So this is there the distinction which sought to be made between the word civil proceeding, which is civil court, which is not appearing in Section 14, is only the word court, and then the court expanded meaning The tribunals, if they are exercising certain powers which is akin to a court, then they may have a trapping of a court.
Yeah.
But mere giving a power to summon the witness, to examine the witness, like by taking aid of civil procedure court, does it mean that it partakes a character of the civil court?
Your Lordship, why I'm submitting this? So far the 49.
I think the Calcutta view is different.
So far the 49(2) subsection 2 of section 49, there reflects what the court and or tribunal. That court should be liberally interpreted. Why, Your Lordship? Why, Your Lordship? The tribunal, as per section 78(5), has the power to set aside the matter. And the first appellate authority, as per section 77(7), has the power to set aside the matter. When the tribunal has set aside the matter, 49(2) can be adopted. But when the first appellate authority has set aside the matter, it is not applicable. Your Lordship, that is for that reason, only for particular reason, Your Lordship, my respectful submission, that it should be, the interpretation should be wider. Because basically, this only for this issue, only in this provision, because both the powers are the same. And it is applicable to the tribunal, it is not applicable to the first appellate authority, though there is no distinction power. So for this purpose, the wide interpretation, I humbly pray that there should be a wide interpretation, Your Lordship, so far as the court is
Then
concerned.
why the tribunalization has taken place? Why in every sphere the tribunals are established under Article 323A, 323B? If those tribunals can be akin to an appellate authority, then what is the necessity of the tribunal to be constituted for that purpose?
Not on, Your Lordship, I'm not, but only Your Lordship, my limited grievance and limited purpose, Your Lordship. And the entire, Your Lordship, what is the intention? What will be the intention of the legislature, Your Lordship, by not? So I leave it to Your Lordship, Your Lordship, because everything is clear, Your Lordship, and it is only Your Lordship's interpretation.
It is not
Many
clear.
cases.
It is not clear. It's still the obscurity remains, may I use that word, ubiquitously present everywhere.
Your Lordship can very well understand my submission, Your Lordship, because
Sir, I want your lordship to see page 57, para 24 of MP Steel. 1 minute only, your lordship.
What?
Para 24 of MP Steel Corporation, page 57 of the compilation I gave you, lordship.
Yes.
There may be some conflict between whether section 14 can apply to appellate authorities between MP Steel. We are not concerned with that question. We are concerned with the question meaning of the word court. Kindly come to page para 24, at page 57 in MP Steel.
Yes.
The stage is now set for a decision on which wide-ranging arguments are counsel of both sides. In CST versus Parson Tools, a 3-judge bench was confronted with whether Section 40 of the Limitation Act applied to sales tax authorities under UP Sales Tax Act. In no uncertain terms, this court held, quotation, Mr. Karkani is right that this matter is no longer res integra. In Ujjamba, with the state of UP, Hidayatullah, 7-judge bench, speaking for the court, taxing authorities are instrument of the state. They are not part of the legislature, nor are they part of the judiciary. Their functions are assessment and collection of taxes, and in the process of assessing tax, they have to follow a pattern of action which is considered judicial. They are not converted into courts of civil jurisdiction. They still remain instrument of the state and are within the definition of the state in Article 12. The above observation were quoted the approval of Jagannath Prasad case. It was held sales tax officer and UP sales tax at 1948 was not a court within the meaning of section 195 of Code of Civil Criminal Procedure, although is required for judicial function. The decision in Jagannath, it seems, was not brought to the notice of the High Court. In view of this pronouncement of this court, there is no room for the argument that appellate authority and judge revision sales tax, excise and jury sales tax act are courts. They are merely administrative tribunals and not courts. And as per Lords are aware, in UP, the judge revision is a civil judge, but he's made the sales tax tribunal. Even then, the court held when he exercises power under sales tax tribunal, he is not a court. The three-judge bench, Your Lordship. There may be some dispute, as my Lord beautifully pointed out with respect to humility. Civil jurisdiction, section 14, there may be slum shades, Sarathi Mudaliar and other MP Steel. That also MP Steel clarifies. But we are not concerned with that question. We are concerned with the question of the court. According to my learned friend, Joint Commissioner appeal is equal to the High Court or Supreme Court. Because as far as I understand, court in tax matters, civil courts are out, district courts are on bar. So only courts are High Court and Supreme Court. So do you mean to say, Your Lordship, Joint Commissioner appeal is equal to the High Court and the Supreme Court? With respect to Lordship, it's a mistake by the legislature. My learned friend is valiantly trying to make up what the legislature missed out. That's what our submission, Lordship. There can't be any doubt on that.
Greatest respect, Your Lordship. I think
Reply to a reply.
I have shown my thought, Your Lordship.
No,
Now I
no.
leave it to Your Lordship.
You have tried your level, at your level, definitely. We'll consider both the distinguishing feature and the other features.
Your Lordship.
This MP still is subsequently referred to in 2019. They have
There.
and
Let us see.
three judges. bench.
Approved.
No, it's not only referred.
But what I'm saying is, Lordship, there can never be any doubt. The Joint Commissioner appeals is a court.
Whether section 5
Huh.
and section 29 of the Limitation Act is excluded
Your Lordship.
by virtue of special provisions in the.
But that's a slightly different controversy.
Let us.
I can concede and I can admit that it is, it may not be a code for all the purpose. Your Lordship, for all the purpose. The purpose here is very limited, Your Lordship. And
Let
the
us see.
hard
Let us see.
limited purpose.
You are taking a plea that when they are an adjudicatory authority exercising the power akin to a power of the tribunal, so why not they will have to have a trapping? Why not they have the trapping of a tribunal? And the section says both the court or the tribunal. So unless he comes within the tribunal, it cannot be. So let us see.
I thought my learned friend is saying the Joint Commissioner appeals is a court, not tribunal, because tribunal is defined in the act. So if he is saying
Yes, I'm well conscious, sir. There is a provision, there is a constitution. I'm well aware. I'm appearing.
his
on the-
contention is not that the
I'm
Joint
well aware.
Commissioner appeals is a
Yes,
tribunal.
yes. Yes, let us see. Okay.
Because there he is tied.
Hearing is
Tribunal is
continued.
defined in the court.
Yes. Item number 5.
Great. Obliged, Lord.
Item number 5.
At a price, the query was put to auction, but there were no bidders because the additional charge that was fixed, the minimum additional charge that was fixed was bit higher. Then all of them requested the authorities. Then the query was put to auction for the fourth time with a reduced additional charge of 180 rupees. Then two bidders participated. One of the successful bidder, he was awarded with the contract. The unsuccessful bidder has filed another writ petition, which is also pending. And intra parties, those writ petitions are pending. And so far as the present case is concerned, this is a PIA challenging the same tender process. That is the issue.
Here, let's kindly remember this. Kindly remember this.
So I have been noticing since the day one I came from the misuse of the PIL concept.
But here, let's.
If private disputes are coming within the purview of the PIL, the PIL is not meant to settle your personal scores here.
Lordship, here, Lordship, kindly see, here the only state, the revenue is the concern, Lordship. We are not on the Lordship
They are saying-
tender.
What revenues?
Lordship,
If they are within their authorities, if they have fixed a particular base price and then invited, and there were three occasions, not a single bidder came forward because this particular means the reserve price or whatever appears to be too, I would say, harsh. then that is within their authority to lower down the base price.
No, Lordship,
One can-
statute
They
never
cannot
permits,
go
Lordship.
on, they cannot go on sitting idle and do not utilize.
More especially, Rule 27, Lordship,
Well,
never permits the state authorities
Hmm.
unless, Lordship, they fetches the pride of the highest bid, Lordship. Lordship, can you see the language?
There is no bid, sir. Where do you get it? Have you not understood? What he says is that they have fixed a particular condition as a reserve price. That appears to be too harsh because all the intending bidders found that particular the reserve price to be unworkable. Nobody participated. Thrice they floated a tender, not a single bid was offered. Now they decided a conscious decision to lower down. And now the bid has come.
Lordship, I have annexed all the Lordship, this is the result of the Lordship.
Now you file your affidavit.
Yes,
We
sir.
will disclose it. The council, the additional government have to bid something that here.
Item number 6.
Reference.
This matter. When you find the next one.
Item number 7.
Wait, please, ma'am.
On last occasion, my lord, the state had taken instruction they had to take, my lord. Now they have filed a counter, my lord.
Obviously, why is of the.
Where is, my lord, that regarding that, my lord, I'm filing an affidavit, I'm not pressing prayer number 1 and 2. 2 and 3. Not pressing that. Sorry, my lord. It was,
So now what you want to do? There's no problem.
they have solved me a counter, my lord. In the counter, my lord, may I see,
Would you like to respond to the?
I will respond to that counter if required, my lord. There are 3.
That's your
Yes,
requirement, sir.
yes, my lord, definitely.
Your requirement, you just
Definitely.
say whether you want.
We will respond, my lord. Yes.
For your rejoinder, how soon you can file, then we'll take the.
My lord, I'm pressing for an interim relief.
Uh,
What is, my lord, the interim relief, my lord, may see for a moment.
Please.
Yes, my lord. What is the interim relief, my lord? Can?
Entire reading,
My lord.
including the prayers.
My lord.
The statute.
My lord.
By subsequent statute.
My.
So there have to be that after you delete the first prayer,
My lord.
whether all the prayers can independently stand.
My lord. It can
In
independently.
view of the pleadings.
My lord.
Which you have made.
My lord, only thing is that, my lord, I want to tell you, my lord, what they have done, first they issued me a show cause.
I understand, sir.
My-
Yeah, that is the argument at the bar.
My lord.
What is the pleading which you have made? Your entire pleading overs around the constitutionality and the legality of that particular provision of
My lord.
of the statute. That
My-
is section
My lord.
212A of the Bihar and Odisha.
Exact, my lord, I cannot trace because those things have been
You
repealed.
delete that, then
My
your
lord.
prayer is that why not you get an exemption for use of the molasses as a raw material for manufacturing of dough.
And my lord, annexed
And-
9
and then
series.
the demand. So
And thereafter, my lord, the 9 series, my lord.
you are saying the demand is illegal because that provision is.
My lord, no, my lord, what I'm saying is this, if I clarify, my lord, the demand is illegal because, my lord, that application fee and license fee, that is not applicable for the storage of molasses, my lord. That is, my lord, if, my lord, I'll show the act, my lord, that is now, my lord, that 76 lakhs demand has been reduced to 11 lakhs. In their counter, my lord, they have given it. In the counter for a moment, my lord, if my lord will.
You agree with the 11 lakhs or you
Yeah,
are not
my
agreeing
lord.
with the 11 lakhs?
My lord, 11 lakhs.
Even your lordship. 27, he's been called for a personal.
My lord, 27, my lord, because the matter was.
27.
Yes,
This
your lordship.
27, my lord, because the matter was fixed.
This 22nd, your lordship, he was called for a personal hearing.
On the new statute, sir.
My lord, I bow down. That what, my lord, I am harping upon, my lord. On the new statute, my lord, I am only saying, my lord, that application fee.
So he has already fixed the date for hearing on 27.
27 because the matter was fixed over here. My lord, what I'm submitting is this. My lord, two things. My lord, if my lord will see for a moment that application fee and the license fee, both, my lord, are not applicable to my case. That is, my lord, first, my lord, my lord, when it has
Raise all those fees there.
my lord, what has been reduced to that part, my lord, 11 lakhs. First, my lord, it was 5 lakhs, 76 lakhs thereafter, my lord. Now they have reduced to 11 lakhs. Now, meantime, my lord, they have.
Hearing they may come to a nil also.
One thing, my lord, they sealed my premises. What I am trying to make out, my lord, they sealed my premises, my lord. After sealing of the premises, they desealed it, but with a rider that you cannot do the production, my lord. Now, that is, my lord, I should continue with my production, my lord. If 11 lakhs is the due, my lord, then it has to be tested by them. Then it has to be tested as per the act.
In a blanket form and cannot pass.
My lord.
If you show your bona fide deposit 11 lakhs, we will say that you can continue with it.
My lord.
The demand has reduced to 11. That will not go to them, deposit in the court, you will consider and then will decide the matter whether you are outside the purview or
I'm
you are.
prima facie, my lord, I am outside the purview because it is the
You
storage
deposit,
fee.
show your bona fide for the interim order. Deposit 11 lakhs.
Interim order, my lord, only thing is that when they have desealed the entire thing, my lord.
Desealed, they have
But-
done it with the conditions that you will deposit that 11.
No, they have not made that condition with regard to 76 lakhs they have.
Interim order when there is already a monetary demand standing at your.
Monetary demand, my lord, has to test it with the act, my lord.
Let it be fixed for hearing on some other day. It's fixed, but no interim order.
My lord,
No interim. If you deposit money.
my lord, can I take that instruction tomorrow? If matter comes tomorrow, my lord, I will take that.
Take instruction.
My lord, I will take that.
Question arise from.
They have, you could only look at them today and the advocate general.
Right. That matter you not see.
Ballot
match.
Mr. Das's, we could not anticipate. So that unfortunate thing we could not anticipate. Really unfortunate.
Yes.
Yes.
G2 address, then let them say what he did as per their choice, so that
We never did.
Lordship, the advocate general is also not well and
Maybe, but
we have to once it starts from the very beginning. because
he is there. Ongoing the matter, so there's not been, so they have been waiting.
2 weeks.
And it was at least on your office and twice the matter was adjourned.
I
Very unfortunate, we can't say. It was not within. Give me a date of any second week.
10th September.
Give me, let them. Let them revert it.
Admission in
Sure.
college.
That is also endeavor.
It is not actually. Item 27. Item 27 fixed for 2 people. Item number 27, sir.
Also for giving an opportunity to learn so many things. And here was a prayer in the written bill relates to 3 orders. That is because the first one, that is a 12 million.
Why if it speaks at 2 p.m.?
Because I have made a prayer before Lordship and the Lordship also. The last time.
Why you make the time?
Because the matter is that serious, because it relates to particularly because there is gross miscarriage of justice and gross abuse of procedure which is being perpetuated. That's the
There is
reason
a
gross-
review against the order. You
Yes.
said that whether it comes within the
Purpose
permanent
of judgment,
judgment.
because yes.
Please,
Then was
I gave you a judgment as well.
well.
Have you brought that judgment of
Yes.
the Supreme Court? You should not.
Here look, 3 orders are important. Because the first order, that is 12/11/2024, which was passed in the main writ petition, which was challenged in the, that is in my prayer, because that is my prayer, because
Have you annexed the certificate copy?
yes, because yes, because page 33, because
Can a single appeal lies against 3 independent orders?
yes, because that is the query, because that I have to satisfy Lordship. Here, because for a moment, just I want to draw your Lordship's kind attention. What is the error? And for what the review was referred? That is 12/11/2024, because all judgments, whatever I will place.
Sir, you not pressed it and then you wanted to recall the order and this has been rejected.
Yes.
Now question is whether you not pressed it or not.
Yes,
That's the question.
that is the question. That is the question. And both the order arise out, principal order is that is 12/11/2024, which is annexed at page 33 plus. Then also can you see how simple this is? It's a 6 page 33. paragraph 2 hard learning counsel for the parties. Pursuant to the order.
You are challenging an order dated 6/5/25 and 8/7/25, not the parent order dated 12/11/24.
That is my prayer. That is my prayer. Kind prayer. That is page 20. Page 20 plus.
Please, I am looking at page 20, sir.
It is therefore humbly prayed that this Honorable Court may graciously pleased to allow this
Set
application,
aside- Yes, allow the application.
setting aside the
Setting
improved order
aside
dated.
what order?
Yes. Then and be pleased to correct the errors apparent on the face of the order dated 12
So
11
that
2020.
means the only challenge is these two orders.
Yes.
If these two orders are set aside, then the question of correction will come. So that order is not under challenge, 12/11.
But for a moment, people
You
are
should also, that it is a patently erroneous order containing certain misconception of fact.
no plus visible error. It is quite transparent from the face. For a
So
moment,
you have not challenged the order dated 12/11/2024. You have challenged only these two orders, 6/5/87. That's all.
in that way, plus of course, I have written please to correct the error.
That is means the consequential to setting aside.
Yes.
That means the parent challenges to these two orders.
Yes, your Lordship is welcome. That's where I consent.
So you can't
No, like that.
go by a record.
One is IA, you are not specifying in your prayer,
And then you
IA
work the new
order,
application.
you are not specifying in your
that-
prayer. Sir. In the main order. So that is the main order, let us pattern.
Plus, you also can, your Lordship, I will come to.
Substance of your claim.
That-
is substance of your claim. As per your prayer.
Plus, I humbly pray that is, plus, I am.
See, before this division bench is the question which is sought to be.
Yes, that is covered by plus Saab Ablal Khimji and so also Samlal Power Limited. Like recited just 2 days back, your Lordship, on the last occasion, I am grateful to your Lordship for giving me that handle. And I have gone through the entire judgment. And for a moment, I am drawing your Lordship's attention to paragraph 113.
That I read on the other day as well.
Yes, plus. 113 that your Lordship will get from my that compilation. That page 47, it starts from page 47. Page number is well marked plus on the right hand upper corner. Thus, under the Code of Civil Procedure, judgment consists of the reasons and grounds for a decree passed by a court. As the judgment constitutes the reasons for the decree, it follows as a matter of course that the judgment must be formal adjudication, which conclusively determines the rights of the parties with regard to all or any of the matters in controversy. The concept of judgment as defined by the Code of Civil Procedure seems to be rather narrow, and the limitations engrafted by subsection 2 of section 2 cannot be physically imported into the definition of what judgment as used in clause 15 of the letters patent, because the letters patent has advisedly not used the term order or a decree anywhere. The intention, therefore, of the givers of the letters patent was that the word judgment should receive a much wider and more liberal interpretation than the word judgment used in the Code of Civil Procedure. At the same time, it cannot be said that any order passed by a trial judge would amount to a judgment, otherwise there will be no end to the number of orders which would be applicable under the letters patent. It seems to us that the word judgment has undoubtedly a concept of finality in a broader and not a narrow sense. In other words, a judgment can be of three kinds for us. That is a final judgment. I am not coming within this volume, but still also I am reading. A judgment which decides all the questions or issues in controversy so far as the trial judge is concerned and leaves nothing else to be decided. This should mean that by virtue of the judgment, the suit or action brought by the plaintiff is dismissed or declared in part or in full. Such an order passed by the trial judge indisputably and unquestionably is a judgment. Then the second type, that is a preliminary judgment. I am also still not coming within the purview of preliminary judgment. This kind of judgment may take two forms. Number one, where the trial judge by an order dismisses the suit without going into the merit of the suit, but only on a preliminary objection raised by the defendant or the party opposing on the ground that the suit is not maintainable. Here also, as the suit is finally decided, one way or the other, the order passed by the trial judge would be a judgment finally deciding the cause so far as the trial judge is concerned, and therefore appellable to a larger bench. Second, that is another step which a preliminary judgment may take is where the trial judge passes an order after hearing the preliminary objections raised by the defendant relating to maintainability of the suit. That is bar of jurisdiction, res judicata, a manifest defect in the suit, absence of notice under section 80 and the like. And these objections are decided by the trial judge against the defendant. The suit is not terminated but continues and has to be tried on merits. But the order of the trial judge rejecting the objections doubtless adversely affects the valuable right of the defendant, who, if his objections are valid, is entitled to get the suit dismissed on preliminary grounds. Thus, such an order, even though it keeps the suit alive, undoubtedly decides an important aspect of the trial which affects a vital right of the defendant and must therefore be construed to be a judgment so as to be appellable to a larger bench. Then last class, that is intermediary or interlocutory judgment. I am coming within the purview of this part. Most of the interlocutory orders which contain the quality of finality are clearly specified in clause A to W of Order 43 Rule 1 and have already been held by us to be judgments with the meaning of the letters patent and therefore appellable. There may also be interlocutory orders which are not covered by Order 43 Rule 1 but which also possess the characteristics and trappings of finality, in that the orders may adversely affect a valuable right of the party or decide an important aspect of the trial in an ancillary proceeding. Before such an order can be judgment, so the trial judge in a suit under Order 37 of the Code of Civil Procedure refuses the defendant leave to defend the suit, the order directly affects the defendant because he loses a valuable right to defend the suit and his remedy is confined only to so it possesses the characteristics and trappings of finality. One plus that order has been passed.
Come to page 52, where paragraph was 20.
Yes, please. Minus. Thus, these are some of the principles which might guide a revision bench in deciding whether an order passed by the trial judge amounts to judgment with the meaning of the letters patent. We might, however, at the risk of repetition, give illustrations of interlocutory orders which may be treated as judgments. These are all illustrations for us. An order granting leave to amend the plain by introducing a new cause of action.
Come to 10 and 11.
Yes, brother. An order granting review.
It is not.
Manus, review has not been taken up, plus. Here, plus,
Rejection.
it is my humble submission
It is
before
a
Lordship.
rejection of a review on the ground that you have not pressed it. If a proceeding is not pressed, that means the proceeding is rejected.
My lord, yes.
Right?
Yes.
No relief is granted.
Yes. Yeah.
So you do this refusing 10
Yes.
is not included. Granting is included. Because those are borrowed from Order 43 of the Code of Civil Procedure.
Well,
And Order 47, Rule 7 of the Code of Civil Procedure.
the order 47 Plus, that is review.
7 or Rule 5. Allowing is appellable, rejection is not. It says.
Plus, order
Rule
partition.
5 or 7.
I'm sorry. I'm sorry. The review is the chapter under order, order 47. That is because 1 is application for review of judgment, and 7, as your lordship has indicated, that is order of rejection not appellable, objections to order granting application.
So rejection of a review is not an appellable one. If it is not an appellable one, does it come within the purview of a judgment? Because it is really a rejection, because the court did not allow the review application. Rather, permitted you to not press means reject.
Because I have neither filed any application to not press the application, nor my client has filed an affidavit.
That is a different issue.
Yes, sir.
That is one issue. It is within the domain of the bench who passed the order to consider. Suppose you are coming before the appellate court, then you have to satisfy that the appeal lies. This is what we really want.
Yes, sir.
So I do not think that this kind of an order comes within the purview of the judgment.
Well, there are other judgments, of course, where you are also going to be satisfied. But I well,
And you are not also coming under 11. 11. Not 11 of
Yes,
paragraph 120.
an order allowing withdrawal of the suit with liberty to file a fresh one.
So that is under order 23 rule 1.
But here it is because I am in a letter patent appeal before
You
lordship.
have not,
There is a hammer.
you have not asked for any leave. Simply solicitor.
Your lordship, for a moment, your lordship kindly see the order. The IA on maintainability was being heard. And even in his objection, the other side counsel has admitted that I have cited judgment, 5 judgments I have cited. I have argued the matter for a long time. Of course, let me admit before lordship where to consider. The rest couple because the matter was elongated and where the issue was relating to, because my principal right has been taken away and order, for a moment, your lordship can see the order date 12/11/2024.
Sir, we have, sir, the difficulty is you are taking us to an order which is not a subject matter of challenge. Please consider, we will definitely look into the order of 12th of November 2024, provided we are satisfied that the order dated 6/5/2025 and 8/7/2025 is illegal, erroneous, and requires to be set aside. If we set aside the order, then we can take up that review application. And then we'll enter into order dated 12/11/2024, where you say that it contains an erroneous or an error or something. But at this stage, we cannot, because the scope of the appeal is very limited.
Well, I'm taking your lordship to another judgment. That is, your lordship will get it at page 104. That is Badula 1 page 2 page judgment plus Badula Lakshmaya versus Sri Anjaneya Swami Temple, 1996, volume 3, SCC 52.
Yes.
Page 104, your lordship will get at 105.
Yes.
Total 3 paragraphs are there. You also can come to paragraph 2. There first the counsel what he submitted with Ramkumar Learning Council to the appellant interlinear contents that the letter patent bench of the High Court could not have offset a finding of fact recorded by learned single judge on fresh reconciliation of the 2 documents arriving at different results than those arrived at earlier by the 2 courts aforementioned. Though the argument sounds attractive, it doesn't bear scrutiny. Again, the orders of the trial court first appeal lay before the High Court, both on facts as well as the law. It is internal working of the High Court which splits into different benches, and yet the court remains one. A letters patent appeal, as permitted under the letter patent, is normally an intra-court appeal, wherein the letters patent bench, sitting as a court of correction, corrects its own orders in exercise of the same jurisdiction as was vested in the single bench. Such is not an appeal against an order of a subordinate court. In such appellate jurisdiction, the High Court exercises the powers of a court of error. So understood, the appellate power under the letters patent is quite distinct in contrast to what is ordinarily understood in procedural language. That apart, the construction of the aforementioned two documents involved in the very nature of their import a mixed question of law and facts, well within the powers of the letters patent bench to decide. The bench was not powerless in that regard. So it is always a law and facts which is appreciated in a letter patent. I am not saying.
It's not that. What you are trying to say there, the argument was that once the single bench has interpreted the two documents in a particular manner,
Right.
then it would not be proper on the part of the division bench to interfere with such finding. The court says that no, when there is a latest patent appeal, the intra-court appeal is provided, though the High Court is one, yet it is divided on the benches. One is a single bench, another is a division.
Well,
In that event, if you exercise the appellate powers, you have every right to enter into the interpretation of the document, and the appellate court may not agree on the interpretation given by a single bench. Obviously, there is no quarrel to the proposition of law. Here is a question is different, whether the order of such nature lies. It's not a question of interpretation of any document or an interpretation of any the dispute which is there. It is a question where the order of such nature comes within the purview of judgment. So that is what we really wanted to know from you, sir. We are stuck up at that stage.
yes, boss. And then, and only, and there was,
You are
in
taking
the
a lesson
lesson,
the power of the appellate court. We are concerned. The Supreme Court has also not concerned, have not gone into the discretion exercised by the trial court, how far the appellate court should interfere. This is all discretionary order.
yes, boss.
There are catena of judgments that what should be the extent. We are on the very, very, I would say, the nebulous point, whether the appeal lies.
Well, the comprehensive test of the judgment that is under letters patent that requires for the requirements, I have just outlined 6 points. That is plus, I mean, that is from that HON'BLE Kimji and so also Samsel, that is 2023 one that also I have given so finality test. Order must have traits and trappings of finality, because here was the order, even the 7/8/2025, the order where my application has been rejected because I have filed an interim application to recall that order on my own affidavit that I have not said so in the open court.
Now, that is what the event which happened before the court is the subject matter, whether it happened or it did not happen.
Yes.
If the learned judge has said it happened,
Yes.
can we disbelieve that statement of a learned judge? Simply you come forward and say, no, it did not happen. Now, what the appellate court should do in this regard?
Well, here was I am going remediless, because
You are not remediless. You may not have a remedy by way of intra-court appeal, but it does not mean that you are remediless.
may humbly pray either may allow me to amend the prayer. I mean the challenge that main order, that is 12. Of course, I have written it.
The limitation has intervened.
No, that is that. And plus here in this case, for a moment you can appreciate, plus a long run process of hearing even is not required here in this case, because that has been decided by the Honorable Appellate Court. Of course, to where my lord is there that I have understood, but I am showing the judgment of the Honorable Appellate Court for such an order where the error apparent is quite apparent on record, it's quite visible, and that is not being corrected, for which not only I am suffering.
I can understand the power under section 152 of the Code of Civil. There is a gulf of difference between section 152 and order 47. One is the review, one is the correction of a typographical, ministerial, accidental omission or something can be done by a court under section 152 of the Code of Civil Procedure.
But Yes, great loss. But one thing was, if your lordship will permit me for a moment to hear the fact of the case. For a moment, if your lordship permit.
For plus, please consider when the very first day we find whether the appeal lies or does not lie. Can we go into or enter into the merit of the case? I'm simply asking this question. Why should be a court having no jurisdiction? Can he decide something on merit? He will say simply whether I have a jurisdiction or not. If he has no jurisdiction, no decision on merit.
Even
No, he cannot decide.
even though I can pray for lordship, I am praying also before lordship. That is, can it be remanded back again for hearing laws? That is laws. Then laws. I think everything will be clear laws. I am ready to appeal because I have already on the second
I think
appeal.
my reaction in Calcutta High Court is rampant in this regard. I do not want to repeat it here, but there everybody knows that what I will react
But we have taken
with this prayer.
So that is one option. I am
Sir, very clear. I must be very candid. You satisfy my conscience, I'm there to pass any order. If my conscience are not clear, very difficult. Prove me wrong, I am ready. Still my mind is open.
Well, yes, that I
No problem. But prove that this notion is wrong. Because I gave you those judgments,
Yes, but
which is troubling me.
yes.
And those judgments are very illustrative.
And also, I am showing two other judgments.
Please show us, because you showed one judgment which does not appear to delivered on the point which we are struggling with.
Well,
Show us
well.
another judgment.
In the judgment,
I have relied in many cases relating to the contempt, whether the appeal would lie or appeal would not lie. But there, this point has not been taken into consideration. That was an appellate right under the statute itself that was considered. We are concerned with the latest fitting.
But here plus your lordship has just I mean in paragraph 120 that there was 15 categories, but those are illustrations plus. Beyond that also, because
I have no quarrel to this proposition that these are mere illustrative, not an exhaustive one. No quarrel, sir. But still, I am saying that one notion one can draw that if the court has said that granting the review is always a judgment, then conversely we can treat it that refusal to the review the judgment will not come under the review. Negative would be implied.
And that is also made clear by the Honorable Supreme Court at paragraph 151 that these are all illustrations.
Please consider what we are saying here, that if the illustration says it is only the granting of the review is coming under the judgment, then a logical inference one can reasonably draw that refusal to review the judgment does not come as it is only granting will come.
It is
refusal will not.
Refusal on a very technical ground. Which,
whatever be,
with the counsel on his own affidavit is saying that
can there be a different appeal against a judgment rejecting or deciding a cause on a technicalities and on merit? Can there be? Remedy would be one against both.
That means looking at the facts and circumstances of the case, that your lordship can expand also. Plus, I am taking your lordship to Asad
I am asking whether it will come.
I am taking your lordship. I may succeed.
Any other judgment?
Yes, I am showing.
Show us.
I am seriously going. Plus, I am
complete your exercise so that you do not have any.
No, plus
please complete your exercise.
Plus, in judgment, page 71 starts. Plus, that is Central Mining Planning and Design Institute Limited. That.
Which
paragraph 10, 11, 13, 14. Come to page 75.
Page
75 plus top right side corner.
Yes.
75.
Correct.
There plus
just a minute. It starts from page 70. 71.
Start from 75. 75, paragraph 10. 10, 11, 13, and 14.
Yes.
Eleven and 14.
What is decided?
14 plus. Paragraph 14.
I have seen.
Yes.
Paragraph 15 I have read.
Eh,
What was the case there? Whether the back wages to the extent of 40%, that was decided by the single thing. And that right was valid and it's from an industrial dispute case.
Yes.
And it went up to the Supreme Court. Supreme Court says that when a right to get the back wages or the employer what he is supposed to do, these rights are vitally affected, then it will be a judgment within the meaning of it. That's so.
And conclusion is paragraph 14 plus. I'm just reading it.
The conclusion is actually.
That is what is the test? What is the test? That is plus
Vital and valuable rights is determined, it will give. No difference.
plus whether the order is a final determination affecting vital and valuable rights
That
and
is what I'm
obligations
saying.
of parties concerned.
That is what I'm saying. But here is the case.
Plus next line is important. This has to be ascertained on the facts of each case. Plus this has to be ascertained on the facts of each case.
So this case is very simple. Facts of the case is that whether
And if
you
we more-
pressed it or you did not press it.
And
This
if-
is the fact of the case.
Fact of the case was
Not me. No, sir. If you challenge 12-11 order, you will. If you have not challenged 12-11, fact is whether you not pressed or not pressed
challenge.
or did not. Anyhow, sorry, next judgment.
Nonetheless, I will challenge it. But I'll also call it some other name.
No. Unnecessarily, I am making more
No.
comments.
No, I am grateful to lawsuit because
No.
it is a process. It is a process for learning. Of course, I have gone through all the judgments. I have given the judgments. But plus what I have understood now, let it come some other time.
No. What do you want more?
Because I have challenged 12-11, but I have the language little otherwise to correct the errors. I should have said that it should have been quashed.
Next. What is the judgment? Shamsel.
Samsel was the latter judgment. That is 78. It is paragraph 18, 19, 22, 26.
18.
18, 19, 22, 26. You'll also get it at page 96. I'm grateful to answer.
But how about broader?
What is that?
There should be some kind of limitations or limits. And broader, can't go.
That is all. So the lawyer will go to the facts of the case. Then your lawyer can understand also how the case is proceeding.
Any other judgment which you want apart from this?
Yes,
Shams,
yes,
Shamsel,
Yes, close.
consider that.
That is Medinapur People's Cooperative Bank Limited, 106. Starts from page 106. Relevant page is 120. Paragraph 15, 16, 17, and 18.
I know. Yeah, the latter part.
Paragraph below 15, 16, 17, and 18. Plus, I have mentioned in the list of citations. That is available to page 120.
Yes. 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 Then this Asadevi judgment.
Intermediate and interlocutor orders passed during the pendency of a case fall under one or the other of the following categories. Orders which finally decide a question or issue in controversy in the main case. Orders which finally decide an issue which materially and directly affects the final decision in the main case.
That is on the line. We'll consider that.
Yes.
Anything more? That you only one. Gauriya Mission.
Yes, yes, yes.
Gauriya Mission.
Medinapur and Asadevi is also there. Paragraph 2, only one paragraph.
Asadevi have read.
One, yes. 30. Plus, I am going remedial loss. My client is suffering loss since last about.
Remedy lies somewhere else.
Huh?
You are not remediless, your remedy lies somewhere else.
Actually, here loss. Not in the Supreme Court. That if, unless I have already made a submission for Lordship, if it can be remanded back, then review can be had on merit, plus I don't have it now. That I will highly grateful to Lordship.
Then any council have an objection because he achieved the purpose. You are
No,
saying
that-
you do not have any problem. No council would say that I have a problem. in
No,
this
that-
situation, because he achieved the
That plus
desired result.
we have to do certain exercise to, I mean,
Let us
pursue the Lordship.
let us- That's all.
And the 5 days a constitutional judgment. Lastly, I have next, that is starts from page 137. Plus, I am just reading the last paragraph. At page 204, that is 6, conclusion, that part,
Yes.
204. The offset of a decision would shall have no application in relation thereto, as it merely recognizes such right, but doesn't provide for a right of appeal. That you'll also kindly appreciate that part. Therefore, they have decided harmoniously the letter patents appeal, the rule should be construed with the CPC. There should be harmonious construction between the two. And here was no document even has been filed. I mean, not to place the application, rather, the lordship will find question of maintainability. For a moment, I am taking lordship to the informed order. That also lordship can peruse.
6-5 or 8-7.
6-5 also.
Yes.
6-5. You'll also kindly see. Sorry. Yes, ma'am. There, paragraph 3 also had gone through. I'm not pressing it any further. There was no document, just I'm repeating, of course, I'm not wasting a lot of valuable time. That no document, no document has been filed either by my client or by myself, not to press the application. Rather, the matter has been argued for a long time, and there was when I got the order, because on the question of maintainability, when if you also will get see the previous order 6/5/2020 previous order, there the application on the question of maintainability, what was filed by the other side, that was being argued, and there also should have decided the case on the question of maintainability. But I got the order that it has been not placed, and
Yes.
and then I have filed an application on my own affidavit that such a
We'll consider whether it lies. Yes. For others, is dictated on 15. No, not 50, 16.
The item number 19, which is about the GST on the NPV.
That, sir, one after, don't worry. We know the consequences of analogous hearing.
Correct. The
Yeah,
provision
not
is
that.
set, just for the sake of informing your lordships, actually both of these levies on the.
No, my lord, that is under GST, this is service tax. It is incorrect to say. It's GST, that is service tax. It's completely different, my lords.
We will take up one after another, don't worry. We have got 18 now. So let them argue on 18. What?
My lords, 18, my lords, I have a preliminary objection. Lordships, I have a judgment of this Honorable Apex Court on the maintainability of the writ petition after the statutory period of limitation is over. This is a, my lords,
The judgment, any judgment which put a better
My lords, there is judgment 2020, 19 SCC. My lords, may I kindly see that, my lords? Then after that, my lords, may I examine the matter on the jurisdiction aspect, my lords?
You show us a judgment. Where is the judgment?
My lords, Mr. 2020, 19 SCC.
Where is that judgment, sir?
My lords.
Where from you have?
My lords, in fact, I'd asked my associate probably is held up, my lords.
How do you expect that we will have that copy?
No, my lords, I'm sorry, my lords. In fact, I could not see the courtroom. I expected my associate to hand over the copy to the judgment.
Then how do you expect?
How do you, this is not a very casual way of arguing a matter where you are just taking a preliminary point and you are just sitting in a comfortable atmosphere without any judgment and all. Everything is to be placed before us. What point you wanted to take? What judgment you are relying upon?
My lords, he's handing over, my lords. He was just outside the courtroom. My lords, Mr. Mahanti will hand over the copy of the judgment. I'm sorry, my lords. At the
Now somebody just entered and rushed in.
My lords, I'm sorry, my lords. He'll just hand over a copy of the judgment that is squarely on the point, the proposition I am advancing. This is 2020, 19 SCC 681. Lordships have it.
Yes.
Lordships may see the first paragraph, 687, the proposition before this honorable court, the issue. My lords, if I may place that paragraph, my lords, paragraph 1. The moot question in this appeal, emanating from the judgment and order dated 19/11/2018, GlaxoSmithKline Consumer Healthcare vs. CCT, passed by the High Court of Judicature at Hyderabad, the state of Telangana and the state of AP, is whether the High Court in exercise of writ jurisdiction at 226 ought to entertain a challenge to the assessment order on the sole ground that the statutory remedy of appeal against the order stood foreclosed by the law of limitation. Here in this case, my lords, the order was passed on 30/8/2024. My lords, the order was communicated on 10/10/2024. My lords, and the statutory period of appeal is 2 months. To the client lies to the Commissioner of Appeal under
No,
section.
there are two aspects of the matter. We are conscious of the proposition of law
My lords.
that since the limitation period for a statutory appeal has expired, so the writ cannot be entertained. But there is no absolute fetter on the part of the court to entertain the writ petition if the court finds there is a manifest injustice.
I bow down, lords.
Print on the face of the record, and therefore the alternative remedy, even if it is exhausted or not exhausted, cannot act as a deterrent for.
I bow down, lordships. What falls on my lordships, I completely agree, my lords. My place, my
That
lords.
was the only question was because the court says that since the statutory period of limitation for filing an appeal has expired, so the writ is maintainable. That we do not. Also, we never said so.
I have not placed all the paragraphs, the relevant paragraphs, paragraph 15 onwards, my lords, if I may place. Paragraph 15 at page 699, my lords. My lords, then paragraph 15, we may usefully refer to the exposition of this court in Titagur Paper Mills, where it is observed that where a right or liability is created by a statute which gives a special remedy for enforcing it, the remedy provided by the statute must only be availed of. I'll skip that, my lords. Then para 16, my lords, next page. Indubitably, the powers of the High Court under 226 of the Constitution are wide, but certainly not wider than the plenary powers bestowed on this court under Article 142 of the Constitution. Article 142 is a conglomeration and repository of the entire judicial powers under the Constitution to do complete justice to the parties, even while exercising that the power, this court is required to bear in mind that legislative intent and not to render the statutory provision otious. In a recent decision of 3-judge bench of this court in ONGC, the statutory appeal filed before this court was barred by 71 days, and the maximum time limit for condoning the delay in terms of Section 125 of the Electricity Act was only 60 days. In other words, the appeal was presented before the condonable period of 60 days. As a result, this court could not have condoned the delay of 71 days. Notably, while admitting the appeal, the court had condoned the delay in filing the appeal. However, the final hearing of the appeal on objection regarding appeal being barred by limitation was allowed to be raised before being a jurisdictional issue, and while dealing with the said objection, the court referred to the decisions in Singh and Hongo, Chhattisgarh SCB, and concluded Section 5 cannot be invoked by the court for maintaining an appeal beyond the maximum period. My lords, then may I kindly skip that. My lords may then come to, my lords, the relevant para 18 and 19. That is at page 704. They have recounted all the judgments. My lords, the exact proposition is at para 20. My lords, I will come to that.
Mr. Mahapatra, here the situation is something different. He has not at all approached the appellate remedy.
My lords, I will come to that. That has also been answered.
That.
My lords, that has also been answered, my lords. In para 20, it has been answered, my lords. I'll come to that, my lords. Then I'll leave it to your lordship. Para 18, a priori, we have no hesitation taking the view that what this court cannot do in exercise of its plenary powers under 142 of the Constitution, it is unfathomable as to how High Court can take a different approach in matter of rejection. Reference to Article 226 of the Constitution, the principle underlying the rejection of such argument would apply on all fours to the excess of power by the High Court, under 226 of the Constitution. We may now revert to the full bench decision of the Andhra Pradesh High Court in Electronics Corporations that adopted the view taken by the full bench, and also the Karnataka High Court in Phoenix Plastics. The logic applied in these decisions proceeds on the fallacious premise. Further, for these decisions are premised on logic that provisions such as 31 of 2005 Act cannot curtail the jurisdiction of the High Court under 226 and 27 of the Constitution. This approach is faulty. It is not a matter of taking away the jurisdiction of High Court. In a given case, the assessee may approach the High Court before the statutory period of appeal expires to challenge the assessment order by way of writ petition on the ground the same is without jurisdiction or passed in excess of jurisdiction by overstepping or crossing the limits of jurisdiction, including in flagrant violation, disregard of law and rules of procedure, or in violation of principles of natural justice where no procedure is specified. The High Court may accede to such a challenge and also non-suit the petition on the ground that alternate efficacious remedies available and that be invoked by the writ petitioner. However, if the writ petitioner chooses to approach the High Court after expiry of the maximum limitation period of 60 days prescribed under 31 of the Act, the High Court cannot disregard the statutory period for redressal of the grievance and entertain the writ petition of such a party as a matter of course. Doing so would be in the teeth of the principle underlying the dictum of a 3 judgments of the court in ONGC. In other words, the fact that the High Court has wide powers does not mean that it would issue a writ which may be inconsistent with the legislative intent regarding the dispensation explicitly prescribed under Section 31 of the 2005 Act. That would render the legislative scheme and intention behind the stated provision odious. Now, this is the ratio, my lords, that is coming out, and on the basis of that principle, the Honorable Court was pleased to set aside the order passed by the impugned order of the High Court and held that the particular appeal was not maintainable.
What about the L. Chandrakumar's judgment of the 7-judge bench of the Supreme Court, which says that 226 can be invoked?
My lord, that is the broad proposition, my lords, regarding the
that is what it talks about, that there is no difficulty in this regard.
My lords, that is as far as my lords, L. Chandrakumar says that judicial review is maintainable against an order passed by any order, any tribunal. They can come to the writ court if there is a violation of procedure.
Correct, because Article 226 is a basic structure.
My lords, here they have clarified, my lords, the position has been interpreted in this judgment. And as far as my lords,
what do you have to say
here,
about it? Any other judgment, then you will have to ponder upon this issue.
Now that the learned friend is raising that.
My lords, one fact, my lords, one last fact, my lords.
No, fact you cannot as a preliminary objection.
No, I'm not on the merits, my lords. On the fact, when they have filed and when they have placed before this court, 30th August they filed it. 30th August order was passed. This was filed in the month of May. After 9 months, this was filed, my lords.
Let us see. We'll see to it that which order. Yes, on a preliminary objection.
My invocation of the jurisdiction of my lords, the 226 is of the premise that I'm not at all within the purview of the service tax regime. And
look at this judgment, because there is some observations which are made so far as the maintainability point is concerned, jurisdiction point is concerned. Everything is taken care of by that.
My lords,
is there anything in your
You'll have to improve the case. He is relying on this judgment. You have to improve your case.
My lords, I'll improve that. Otherwise, my lords may I only humbly submit, my lord. This is a corporate matter where actually,
sir, I am again saying there are certain observations which are made. Please consider there are I may not, as we can't assume the advisory
Correct,
jurisdiction.
my lords. No, no,
Please
my lords,
consider.
we are always guided by my lords.
Please consider in that perspective.
My lords.
Please consider in that perspective, come ready.
All right.
Answer this on this preliminary point. A preliminary objection is raised on the maintainability of the writ petition after the expiration of the statutory period of appeal provided in the statute.
Section 85.
The reliance is placed upon judgment of the apex court rendered in case of it is always a problem. I have not any multiple times I Tuesday.
In the meantime, I may humbly request, my lord. I actually approached this Honorable Court only because of the substantial questions of law which your lord.
Oh, I understand, sir. Please come. Please come when he is raising an issue. Please come and assist the court.
Yes, I'll assist your lords.
This has a larger ramification and impact you do not know.
My lords,
Please come.
Yes, I'll come with my lords only request, small request. Your lordship may kindly fix it at particular time at 2 o'clock.
Please tell us. We are, sir, that he cannot be done. That everybody is waiting for their turn. We'll take up the matter. On Tuesday, you want?
Yes.
Tuesday.
Item 19.
Deeply grateful, my lords.
Same matter. You are taking a same.
Sorry, my lords, for the-
Yes, same.
Item number 20.
Right, adopted that 29/7/2025, paragraph 4 was pleased to direct the current senior council to obtain instruction.
Now he is no longer there.
And then thereafter another date was fixed. In that date, your lordship was.
He is what?
Regarding the GST, I have to obtain instruction, and the CBIC have no, the commissioner have no role to do in this adjustment. Only GST council I have to take instruction regarding that.
So it was there on your prayer. It was adjourned.
I was taken, but they are unable to say on this thing. I have to talk directly with the commissioner regarding this thing, or regarding that what they will be done.
Next week. Come.
Item 21.
My lord, my humble submission before your lordship that my.
Come on the next week. He will take care of everything. Come on.
Item number 21.
As a master.
Yes, as a special chance. What is the charm in last chance of? Let them. Yes, come.
Next week, GST advisory report.
Next week there is a meeting, so that I said that can you brought the conference?
What the next week means?
Take 2 weeks.
What is a meeting? What?
GST council is there. So next week.
When?
Maybe.
Monday, Tuesday, next week, Wednesday, what?
You have a difficulty next week.
Definitely lots of GST and council, we have to obtain that instruction on how to do this career. I have to talk with the commissioner because of.
On the 8th.
Yes, next.
Item 21.
Sir, these are all court with the career. Court proceedings, you have to be vigilant.
Right.
And you have to get the instructions as per as per our orders, not as per your
I had some
wish.
instruction, but that is not viable.
So whether you talk to commissioner or
Have you issued a notice on the Attorney General?
Yes, sir.
You have challenged the virus of the several provisions of the Central Act,
Lordship, principally the challenge is to the notice dated, my lords.
but you have your prayer A, B, C,
This, your lordships are right.
and D also.
It's challenge to the provisions relating to the IASD, your lordships are right.
So the notice has to go first to the Attorney General
Yes.
or the DSG if he takes. You are
I'm according to the Union of India, opposite of-
Union of India. Do you accept the service or waive the service or notice?
Yes, I'll actually.
why this matter?
Why this matter?
You are accepting.
Yes.
Yes,
Yes, but they're challenging the virus of the.
correct. So then you are authorized to argue on that.
Yes.
Yes. Yes, what do you say why it is
Lordships. May this submit-
unconstitutional?
Lordships, may
Why
this
is not intra-virus?
Lordship, but the mechanism, Lordships are aware, Lords, under the GST law, the same assessee in different states is considered as a different person, Lords. So my plant in Maharashtra, my plant in Goa, my plant in Orissa, and my depot in West Bengal are all considered as different persons for the purpose of GST law. Lordship, now because with great respect, they may say it is one nation, one tax. According to me, it's a state law now. GST is a state tax because on an intrastate supply of goods and services, there are two levies. One is CGST, another is the state GST. So on the same transaction, on the same supply, two taxes.
Because it is bifurcated, the total, the percentage of the tax is bifurcated.
50-50. But there are two levies. So the assessing officer passes an order that you are liable to pay 100 rupees CGST, you are liable to pay 100 rupees SGST.
Because it's the one authority who has to decide both.
Who has to pass the order? Now, in the present case, what has happened? There was an investigation undertaken saying that you, the recipient, have not gotten correct credit because the ISD, the input service distributor in Goa, has not given you correct credit.
Have not given you?
Passed you the correct credit.
Okay.
Lordships. My first submission would be, Lordships, I sitting in Bhubaneswar.
This is relation to ITC.
Input tax credit. No, this is not, it's only distribution. They are not questioning the eligibility. In fact, they had sanctioned the refund to me. They are not questioning the eligibility. This is not that fake ITC case, etc. I mean, we don't appear in that. It's not that. This is my Goa unit, my left hand, my Goa unit giving it to my Orissa unit. So to the right hand, same assessee. Assessee is the same, PAN number is the same, only registrations are different. Their case is that you have not distributed the Goa unit or the Daman unit has not distributed the credit correctly. They have committed some mistake. Therefore, you, the recipient in Orissa, you bear the burden. Because my first submission would be the jurisdiction lies at Goa. The Goa officer has to first examine whether the credit is right or wrong. I sitting here, my lords, cannot decide that that is correct or not. Secondly, what they have done is, my lords, they issued a notice saying that Goa, Daman, Tamil Nadu, everything will be adjudicated in Orissa. Because from where they derive this territorial jurisdiction. They can adjudicate for Orissa no difficulty, my lords. They have jurisdiction. How do they adjudicate for Tamil Nadu? Or they adjudicate for Goa or Daman? That's the second point, my lord, that we are raising as a jurisdictional point. The third submission is, my lords, the present notice that they have issued is, my lords, for the financial year 2017-18 till 2022-23. It's a common notice. That's a fundamental mistake, fundamental error, my lords, because now under GST law, it's like income tax, my lords, now. It's like earlier says.
There are many matters which are still
Yes,
pending
because
before
these
this court.
matters-
That where the composite notice covering several periods, whether it is permissible or it is not permissible.
Lordship, one matter where Lordships have passed an order. This court is examining, your Lordships have passed an order. There is a judgment, recent judgment of the Madras High Court, the Karnataka High Court, Division Bench of the Kerala High Court, all have taken this view, my lords. The first page itself is your Lordship's order. This court examining the same issue in the matter.
Mr. Mishra, very much technology has been referred to in one of the orders, and I think matters are pending. You are one of the parties here. Opposite party number 2.
Yes,
State of Odisha.
State.
Finance Department.
Yes,
Mr. Counsel, you are not appearing for 3 and 4.
You are appearing
For 1 and 5.
Also, you said
1 and 5.
then 3 or 4. 3 and 4, who is appearing?
normally DGJ matter, Usha Supreme appears previously.
But I'm asking you from the right from the beginning, my lord is asking this question: who is appearing for whom? The opposite parties are to notice. 1 and 5, he is appearing. He has filed his memo.
In fact,
And 2 is State of Odisha Finance Department. You must be appearing. You must have been given a copy. And no, you are not made party, Mr. Mishra. You are not made party, Mr. Tripathi. Then 3 and 4, DGGI and Commissioner GST Central.
No. State.
Somebody is on the screen.
3 is Central.
Central. 4.
4 is also Central.
Oh, Journal.
DGGI. দেখুন তো মিস্টার কেডিয়া সেটা দেখুন ইকুইপমেন্টটা দেখুন তো এটা খোলো তো
I don't have the feed with me.
So far as the validity is concerned, he should make us all as party also, as opposite party. He has not made.
No, you are not made party here. He didn't choose you to make party, so you see. No, very much I have seen somewhere that interim order.
No, there also the Veramex was considered. We just wanted to know whether the Veramex has been disposed of or it has not been disposed of. It's still pending or?
Multiple assessment.
Next of Karnataka report, we have referred to in one of the orders as interim order. In the interim order, we have referred to and we have issued notices.
The number.
Page 12, Manoj, Veramax.
Oh, page 12, he is referring.
Yes, Veramax is the it's disposed of, Manoj. Page 12 is the Honorable Karnataka High Court judgment.
So
in
that,
Veramax.
that judgment reference we have made in one of the cases, and many cases in this line is pending. We have issued notices.
Yes,
that's why we are asking.
No, it is disposed of. But it is disposed of on the same day.
Veramax.
September.
Make you angry.
The virus, what about, we understood. What about the virus?
But if the notice goes on this ground, I will not trouble your lordship with a larger challenge.
Why not? we have to see whether the virus can be
No, that also I'll satisfy lordship independently. Because
it is-
lordship decides like saying, if he has committed a sin, you have to be prosecuted for it. That cannot survive. My lord.
No.
We have challenged on that ground.
On that ground, let us see, is a fiscal statute.
Certainly.
You have to bear in mind.
But see, lordships are right from RK Gar. It's a fiscal statute. They have wide latitude. Certainly.
Yes.
The challenge is that, my lord. Your lordships are right, my lord. I'll satisfy your lordships with that also.
Yes. He has this notice. There is no difficulty.
On 5 August 2020, WPC number 18186 of 2025.
What is
That is
same
practiced.
we have passed. Stay has been granted. Interim order is there.
Down to the
Yes.
petition is
Yes.
interim order will be made.
So say,
Multiple periods.
so then what is the sauce for a gander is a sauce for a goose? Same treatment. Why don't you plead them as a party?
Here, no, state is a party.
State is not a party.
Responded to.
Finance
State GST concern.
Oh.
Mr. State, oh,
It's a-
state is party.
No. No, now there is a division.
Lordships.
Now, so far as the panel lawyers are concerned, there is a division.
State of Orissa to the finance minister.
No, that is what is this. Now, so far as the GST is concerned, right here.
So far as the guidance is concerned, you'll not remember.
Lordship responded.
Justice Raman might have remembered one
Responding to
JSW.
we have said finance department. We have, sorry,
Commissioner, Joint Commissioner G.
central.
Center.
So,
Because he's the
we,
person he was,
he's a state.
no, because this is the person who is actually
You are adjudicating means the state authorities is adjudicating.
state. No, this is center. Lordship, I quite
My
I'll add
learning friend has argued
I'll add it.
that 50% state is.
That is why I told him what he's doing.
I'll add him. I'll add him as a
His first argument was left hand, right hand. I understood.
Lordships.
So that's why I just reminded him that be careful about your own submission. Leave is granted to the petitioner to add
Be obliged.
Huh? Consolidated cost title will be filed that time.
Item number 22.
20?
2, my.
In item number 22, I will be appearing for the department, my lord. In item number 22, I will be appearing for the department because Mr.
Yes.
Satpathy is appointed as the member, judicial member. 2 weeks time may be granted because the brief has not been transferred yet.
Has not been transferred to him. It's 2 weeks. Next.
Item 20.
Matter will be listed along with this connected appeals.
Don't worry. Let the first matter be decided. Don't worry.
Item 23.
Will be certain.
Yes.
23.
Item 23, the conducting council is out of its.
How much? 2 weeks?
24.
It's a very small matter.
Small matter.
Very
You don't appear in a small matter.
little.
You always appear in a very big matters. Complicated question of law, complex facts.
Even compliment or satire, I don't know, my lord, what I.
Yes.
Small matter that is.
The arguing counsel is under.
Who?
The arguing counsel is appearing matters under.
Who?
Anurag Pati.
Which matter?
This matter.
24.
For the opposite party.
Appearing for the private office.
Oh, I do not find your name here.
Anurag Pati, Pati is there.
Oh, yes. He was there on the first day.
It's not here.
When? Next week?
Any date, second week of September.
Second week of September.
Then let this impute order maybe during. But I face termination, my lord.
Nothing. Madam, your brother fraternity, your brother is ill.
Objective.
So how can you so unreasonable?
Your political parties.
Whatever we are not concerned with the political. We are concerned with his personal. Give it on second week 8. 8. Yes.
Item 25.
Yes. What is this?
Order passed by Honorable Single Judge, my lord. Last occasion, the lordship has heard this matter. He directed the State Council to take instruction about why my appointment order was modified after 1 month.
Huh?
My appointment, I was selected, my lord, pursuant to direction of this Honorable Court.
Yes.
125, my lord. And thereafter, my lord, after 1 month, some days, that was modified, my lord. Saying that my appointment has been cancelled.
Modified by whom?
By one of the collector and district magistrate.
So, on what ground?
I'm an SSG, my lord. I'm an SSG, self-help group, my lord.
Okay, self-help.
Appointed for preparation and distribution of THR articles, my lord. Take home ration articles. Because pursuant to
whatever, then
earlier, my lord, they have selected opposite part number 5 and 6. Against that, my lord, I have referred a writ application before this honorable court, my lord. The relevant page is 83, my lord.
So what?
Yes,
so,
my
so
lord.
rejection, cancellation, why it has come?
Lord?
Have you suppressed any material fact?
No.
Have you gave a wrong information about your antecedents?
Nothing, man.
Anything?
Court has directed to give reference to the petitioner over and above opposite part of 5 and 6, man.
Okay.
On that basis, my lord, appointment order was this. They selected me, man. Your lordship see the approval letter, page 125, opposite part number 5 and 6, they have been renewed up to 31/3/2025. Whereas I have allowed to produce and distribute THR.
What is your stand? Why you have cancelled his appointment after giving the appointment and thereafter you cancelled it? Yes.
In fact, his periods had expired. Subsequent,
Oh, the time was extended and later on it was withdrawn. That in the meantime, you have by process, tender process and everything is completed. Appointment?
Yes.
So tender process is not.
What?
They have selected, your lordship may see the ordering portion of this honorable court, madam. Page 115, madam. Paragraph 43. As per clause 1 of the agreement, the same is valid for the financial year 23-24. From clause 4 of the said agreement, under heading termination of contract, it is amply clear that the said agreement shall expire by a flux of time or by notice in terms of clause 3, as quoted above. In view of such submission made by the London Council for the opposite party, this court observes that the fresh advertisement is made inviting application for preparation and supply of THR under SNP, but so the petitioner's SHG shall be given preference, taking into consideration its past experience and carrying out the said job effectively and continuously since 2011 till March 2022 in terms of the revised guideline for implementation of take-home ratio. Since tenure of the opposite part number 7 and 8 have been completed and the agreement period is over, the prayer to set aside their selection and appointment as THR to deal with preparation and supply of THR by letter dated 26/5/2023 needs no further order. However, it is made clear that in terms of clause 4.1 of the agreement, no decision shall be taken for renewal of contract in favor of opposite part number 7 and 8. So that has been, court has categorically directed not to renew their contract, man. In view of the above court direction.
What they have done?
No,
They have renewed the contract or what? What is the ground for rejection?
Lordship may kindly see para 45 of that letter. Para 45. For a moment.
What?
In view of the above, this court directs that for the ensuing period, all the contenders to be selected as suppliers of THR must be dealt in a fair and transparent manner, and in view of the admitted facts on record, the case of the petitioner SLB shall be considered by the authority concerned in terms of the revised guidelines representing both. The Honorable Court, while directing to consider his past experience, has also directed to follow a transparent and a fair procedure one.
Yes.
Now, by virtue of this order, if you will also may kindly see page 125. 125. With reference to the subject cited above, it is to inform that the district level renewal committee, Bhubaneswar, has been pleased to renew of the existing THR units in your concerned project. As per the order passed by the Honorable Court in WPC number so and so, may be allowed to produce and distribute THR along with other two contenders, that is Ma Durga SHG and Jai Ma Durga SHG, that is 7 and 8, in the Baleshwar municipality.
So now it was up to 31st of March 2025.
Yes.
Yes.
So now the March has gone.
Yes.
We are in the month. Then what to do? What has happened thereafter?
But thereafter, he again approached this Honorable Court.
Who?
This present appellant. He approached this Honorable Court in another writ application that is at page 138, which is the order which is the subject matter of the present appeal.
Now, the after the expiration of the period.
Yes.
Yes.
Again, my lord, this opposite part of 7 and 8, now here opposite part of 5 and 6, they have been renewed, madam. Contrary to the order passed by this honorable court.
What renewed? Where is the contrary order?
Well, now they are continuing, madam. Opposite part number 5 and 6.
This the renewal was these two persons. Renewal was already there.
Renewal there up to 31/3/2025.
Correct. Thereafter, that is within their authority whether to further renew or not to renew.
No, court has directed to go for selection process, madam. Without going through selection process, court has directed categorically not to renew their contract.
Where is the categorical direction not to renew? They
Yes, madam.
renewed. Where is the
Paragraph 44, madam. Paragraph 44.
Of what?
Of the earlier order, madam.
Which earlier order? Date?
Page, madam, page 116.
Paragraph
44. Since tenure of opposite part number 7 and 8 have been completed.
116.
Yes, madam.
Which? Where it is? I'm unable to find. Yes.
Since tenure of opposite partner 7 and 8 have been completed, an agreement period is over. The prayer to set aside their selection and appointment as TSR to deal with preparation and supply by letter dated 26/5/2023 needs no further order. However, it is made clear that in terms of clause 4.1 of the agreement, no decision shall be taken for renewal of contract in favor of opposite partner 7 and 8, ignoring the case of the petitioner.
Yes. No, your case was that will be considered by the authority in terms of the revised guidelines.
Yes, my lord.
So what the revised guideline says?
The revised guideline says, my lord, before the end of 1 year, my lord, on that basis, my lord, court has disposed of. Since the tenure is over, it is for a 1 year period, my lord. The tender is for a 1 year period. That period was over. That's why court has directed to go for fresh selection instead of renewing the SSG, my lord. Now, your lordship may turn to page 125. Again, the authority have renewed their contract, my lord. And renewed up to 31 through only 2 days, my lord.
So go there. If they have violated this order, then
No,
what
that-
remains?
I have filed a writ application challenging this, my lord.
Then why the single bench dismissed it?
No, dismiss no. Single bench says, my lord, that appeal lies to state director, my lord. There is no appeal, no such appeal lies, my lord. Because the same court has entertained other application, my lord.
So once the court has committed mistake, so
Yes.
it will continue committing mistake. That
Paragraph
is what
9,
you
ma'am.
want to say.
Paragraph 9.
That is what you want to say, that once the court has committed a blunder, it will continue to commit blunder. It cannot rectify at any point of time. Do you want to say that?
No. Paragraph 9, my lord. Court has construed, your lordship may see paragraph 9, my lord.
Yeah.
Paragraph 9, page.
File your response to it. Have you
142.
filed your response in the trial court?
Yes.
Had you filed your response in the trial court? Yes. So fix this matter after 2 weeks for hearing. That is left.
Item 26.
Yes.
Wait, please, Your Lordship.
Oh, you are appearing in 26.
Yes.
Yes.
But in this matter, what I'm challenging and jumping in orders passed on a writ petition filed by my client. But I tell you, Lordship, just shortly the background. But my client was entrusted in the railways to construct, my lord, siding, railway siding, for the purpose of transport of iron and steel materials. Now, this is between, my lord, the place, between the place, my lord, Badajamla and Badville railway station. So, my lord, I identified, giving my lord the drawings with regard to this, the location of this. This was approved. Then, my lord, I was asked to give a detailed project report, which I gave. I was, after my lord, that was approved by the railways, that detailed project report. I was asked to deposit, my lord, 5 crores of rupees by way of security, which I deposited. Thereafter, my lord, I shall give your lordship a list of dates on that. My lord, thereafter, I was asked, my lord, to pay certain amount of money by way of administrative cost, about 8 lakhs around rupees, which I paid. Then I undertook the job. The job was, I shall just indicate to your lordship what the job was. Your lordship knows the railway lines, my lord, are on high land. On the 2 sides, my lord, the slope, and thereafter, my lord, the paddy field and things like that. In the instant case, I was to, my lord, construct, my lord, an embankment. to bring it up to the
Level of the
level of the
track.
and will not construct this. For the purpose of that, I was entrusted to procure privately land for such purpose. About 20 acres of land I purchased for the purpose of this. Then, my lord, I undertook the work of preparing the embankment, which I did. I raised the land, which was about one and a half mile in length and about 300 meters in width. That has been done. The photographs are there. This was done. I procured the rails, the sleepers, and my lord, these tying things. I also, my lord, procured, my lord, for the purpose of raising the signals, the electric signals. I procured the materials. When it was like at that stage, the railways, without giving me any notice, any hearing, purported to foreclose this particular contract on the ground that I did not complete the work within that time. Now, in the meantime, I shall also indicate to your lordship, there was an agreement between the parties that a land licensing agreement will be given by the railways for the purpose of connecting the siding rail with the main rail. Now, that has to be done by the railways. The railways did not do that. They may not drag their feet. There are internal correspondence, which I have annexed here, where my lord, one department is writing to the other department that why is it that the present valuation of the land had not been given, which is impeding the course of preparation of that. Now, at this stage, my lord, they issued the letter and my lord terminated my contract. But I am now out of pocket to the extent of 5 crores by way of security, which they have pocketed. I have, by way of administrative charges, about 18 lakhs of rupees. I have, my lord, that is gone. For the purpose of procurement of the land, huge amount of money has been spent. Now, my lord, for the purpose of preparing the embankment, I have procured, my lord, the ballast, the stone chips, etc., and my lord, the soil and things like that. These have been done. I have procured, I have shown, the photographs are there, which were annexed to my petition. The rails have been procured. They are lying there, open to the sky.
Then what the single bench did?
My lord, what they say, if your lordship kindly comes to the interview notice, kindly, my lord, come to the notice at page. Lordship will please to come to the letter of the railways by which they did it. Parentally, page 173. This is a letter dated 9th March, which I have challenged in these proceedings.
9,
At
letter
page 173.
173.
Yes, at the
Hey,
page.
Barkov.
Kindly ignore the page number which has been given in the middle. One of the page number on the side. 173. Your lordship has got that.
Just 1 minute. Yes,
This is a
I got
letter
it.
which was written on the 9th of March 2017.
Yes, I got it.
The in principle approval of the siding proposal on private land
No,
between
that is what you said. That there was already in principles and everything has been done.
and DPR, detailed project report was
It
also
has also approved and
Yes.
no, I just wanted to know that why the single bench.
Yes, my lord, kindly come to the 3rd paragraph. You will appreciate that railway cannot keep the approvals open beyond a reasonable period of time, because this might deny opportunity to some other potential investor at your referred location, totally forgetting that the location has been purchased by me. Nobody else can come in there. A considerable time has already been elapsed. No action has been taken. It is therefore concluded that you are not really interested to develop the above mentioned
Which
private
page
site.
you are referring?
My lord,
This is 15.3. What is this?
March 2017.
Page?
Page 173.
See, okay.
Of the
Yes, sorry. Yes.
This my lord, third paragraph and fourth paragraph I read. My lord, on the basis of which they are purporting to foreclose this particular license.
And forfeit all the non-refundable registration
Yes.
fees along with the codal and department charges.
Well, I do not know what to do with this. Well, I have parted with 5 crores. I have parted with my lord 8 lakhs and odd. I have my lord expended that amount of money for the purpose of procuring of land. I have expended that amount of money for the purpose of preparing the embankment. I have also my lord spent that amount of money for the purpose of procuring the slippers and my lord the.
No, I understand. Then what the single bench did?
This what it said, my lord, and unfortunately, this is what my lord, completely ignoring the evidence on record. The learned trial judge has been pleased to observe. I shall take your lordship straight to it. My lord, I do not want to make a statement which is contrary to record. Kindly, my lord, come to page 43, the impugned judgment. The paragraph which, my lord, is we are concerned with. Kindly, my lord, come to paragraph 20 at page 61. This is, my lord, wrong. This is the perverse finding of fact. Kindly, my lord, come to paragraph 20. Page 61. Your lordship has got that?
No. Hey.
Of this paper book. The chronology of events clearly establishes that the petitioner had ample opportunity and time to proceed with the construction on its own private land with a detailed project report DPR approved as early as in 2010 and subsequent approval of ESP on 19/11/2010 and bridge drawing on so and so. There remained no substantial impediment to initiate the proceed with the construction of the private on non-railway land. Clause 1 of the DPR, the inaction. Your lordship kindly sees this inaction. And I request your lordship to look into the petition where, my lord, this was given and this was drawn the learned at trial judge's attention also. Page 163. Kindly, my lord, compare this paragraph with page 163 where, my lord, evidence has been produced. And in fact, page 163 is one such only. And there is not a single letter from the railway. I say that without any fear of contradiction. There is not a single letter from the railway complaining of the delay in execution of the work.
Where is the railway?
Women of India.
Well, I really was absolutely puzzled. Can you come to page 163 once? Just for my satisfaction. Your lordship will kindly take the trouble of coming to page 163.
Yes.
On, my lord, there is, I say this, my lord, without any fear of contradiction. There is not a single letter from the railways complaining of the delay in execution of the work. Because they know exactly what work I am doing. They are visiting the site, seeing, my lord, what work I have undertaken, what is the amount of work I have completed. Well, and kindly come to page 1. And for all friendly letters, you do this, you do that, guiding me as to what is to be done. Kindly, my lord, come to page 163.
163? No, 163 is written by you.
Yes, kindly, this is what I gave to them. And
with reference to their letter dated 20th of April 2015.
Yes. Well, kindly come first to come to page 158. I would have thought that if the progress, kindly see, my lord, this letter. This we are writing to, my lord, the Southeastern Railway, the transportation manager, progress report of proposed private railway siding of so and so.
So you have already given that.
And then, my lord, we are given work of progress, page 159. What has been completed, what are they approved, and what are the things in process. Work in progress, we have given. Then, my lord, kindly see, completed, page 160. Bridges, drain, retaining in progress. Construction of earthwork, completed. Bridges, drain, retaining, well, in progress. pathway in
So,
progress.
so the single bench proceeded to dismiss your writ petition.
Yes. And my lord, I respectfully submit to your lordship 3 points on this is a question of fact. I am submitting to your lordship that this is perverse because my lord, the evidence which was on record had not been taken. First. Second point is this, my lord. When you issue this notice, the interim notice of March, you are to give me time because time was not of the essence of the contract. Section 55 of the contract Act comes into existence. You are to give me notice, making time essence of the contract before you can terminate. Otherwise, my lord, you cannot terminate that. There are judgments on your lordship knows. That has not been done. Thirdly, it's a clear violation of the principles of natural justice. Starting from Mahinder Singh Gill, my lord, up to 2025, Supreme Court, one of the other judges has said that where, my lord, any action is taken which results in civil consequences, hearing is a must. If you do not do that, you violate the principles of natural justice. And if you do violate that, then the action becomes void. That's the third point. But fourth point, I have indicated to your lordship that without giving notice, you could not have made my lord, you could not have terminated the contract, could not have foreclosed. But these are questions which require to that. I am ready, my lord, to make my submissions on this. And I will be able to convince your lordship that, my lord, this particular order should not be sustained, my lord, that particular thing. And after your lordship kindly comes back to, my lord, if I may just trouble your lordship with this, kindly come to page 163 once more. This was there before the judge. How is it that his lordship was pleased to hold that there was total inaction on my part? 4th May 2015. And my lord, as I submit to your lordship, there is not a single letter of protest. What I would have expected, that if a person who is entrusted with a work, he does not do the, then the person for whom the work is sought to be done, he should have written one letter that what are you doing? You are sitting on the work. You are not doing anything.
So there was the correspondences flagging any lapses or the latches or the violation of any terms and conditions of agreement.
No.
And suddenly by one fine morning, they just slapped you a letter that your contract is foreclosed.
Yes, this is the first time they had written to us that look, since you are not doing the work as you are.
Mr. DSG, what do you have to say about it?
My lord, this writ appeal was filed against the order of the Honorable Single Judge.
Yes.
And the Honorable Single Judge come to a conclusion. Before that, there is one paragraph I am just enlightening.
Now he is challenging this particular order of the single bench on the ground of perversity. He says that there were sufficient materials which was available on the record. Had those materials been taken, the findings which have been made in paragraph 21 of the judgment would not have come. And there cannot be any perception that there was any fault on their part. This is what they wanted to argue.
Yes, my lord.
Basically on the ground of perversity.
Yes, my lord, it should be read conjointly because prior to that paragraph, my Honorable Single Judge has read all the facts. Not only this,
Facts. What he says that the facts which might have been narrated, but the relevant facts has not been taken into account, which is corroborated by an evidence on record.
It is a appeal in this ground. We have taken specific ground in our filing counter, and the Honorable Court has passed the order explaining all the facts in the judgment itself.
There are two aspects of the matter. First thing is that you are terminating a contract without giving a notice, without giving a time to remedy whatever the defects that has come. Secondly, if it invites a civil consequences, unless there is the clause for termination without giving a notice.
It's a matter of hearing, my lord.
That is what it says, that the time is not the essence of a contract. If the time is not the essence of the contract, then
It
the
cannot be.
in
Time is
the
essence of
incidence
contract
of
is always
then the
it's a
incidence
fundamental
of
law.
section 55 of the Contract Act gets attracted. That is
No,
what
but-
his argument is.
But they agree. No contract is there. The time is not essence. It cannot be, my lord. Without fixing the time, how can a contract will come into force? Yes, it cannot be. What I am saying, my lord, this is the first time the appeal was filed. Let it be. They will hard. Any date may be fixed. I will present court and I'll agree better.
Okay, tell us any date.
Let's see, maybe fix the next week or 1 week after 8th or 9th.
Whatever is
9th or 10th.
convenient to the members of the bar, I have no difficulty.
No, my lord, 10th or 11th.
Yes?
10th of September or 11th of September.
Yes, Mr. Mitro.
Your Lordship, kindly give me
My
one.
learned friend may see what is the convenient date for him also.
10th of September. 10th of September.
10th or 11th is proposing.
10th, 11th, 12th.
10th is Wednesday.
10th is Wednesday. Well, can it be on a Tuesday?
Yes, yes.
9th.
If it is convenient to my land, my lord.
9th is fine.
9th.
9th.
Yes, yes.
Kindly, my lord, fix the time, my lord. Can it be at 2 o'clock? Then, my lord, it will be. This is.
My lord, 60 years in the bar. He has the privilege. This completed 60 years. He was 2 years old when he joined.
I was not born.
Well, it is surprising that I am standing in front of you.
No. We are so happy you're standing.
No. You always have, there are some seniors
He's
still,
one of the last left. That is what.
that school is still continuing.
Yes.
Now that school is completely